Evening all, Al Diorio here. I'd like to call this evening's meeting to order. I show 6:04.
We're back. Sorry about that, folks. I believe that we are having some technical difficulties here, which are related to our internet connection. We still do not have any internet access at this point in time. I'm going to have to contact our IT professional.
You're gonna find that he's
Oh,
in.
nope, we're back. We're back. Don't have to call him. Anyway, I believe that we are okay to proceed now. Hopefully we will not have any further interruptions of that nature.
Think we're good?
Yes.
So, before I was rudely interrupted by technology, I was about to engage in the roll call of the members. So once again, Diorio present.
Relowitz present.
Lindelof present.
Light present.
Shamshinia present.
John Pennypacker present.
Very good, thank you. Next item on the agenda is a pre-roll. This is a indication of your attendance for the upcoming August 4th regular meeting. Diorio, I plan to be here.
Relowitz, I plan to be here.
Lindelof plan to attend.
Light, yes.
Shamshinia plan to be here.
John Pennypacker also plan to be there.
Very good, thank you. Next item on the agenda, under old business, first item, third master plan. Public informational meeting, major land development project, Stone Ridge at Hopkinton, AP 11 Lot 47A, 0 Palmer Circle, RI 95 LLC applicant. Maybe I could impose on Jim for just a quick recap of where we left off and where we are going.
Yes, Mr. Chairman, at the last meeting that we had on July 7th, we were searching for some sort of an indication from the planning board as to which way they were leaning, might be leaning in terms of a decision, in order for our solicitor to craft a skeleton decision, which she has done and provided. It's an excellent job. So it, with that said, it's expected that it's going to be amended to some degree, and we're prepared to go through that this evening. We've gotten a couple of comments from planning board members that we forwarded to our solicitor for incorporation into it, and so that probably calls for some discussion. We're at motion time right now.
Okay, so we've heard from the applicant, we've heard from any other involved parties. We've heard from the public, and it's down to the planning board in a discussion of a possible motion.
Yeah, the public information meeting is still open at this point, and I don't see the harm in just, giving a last call for any public comments prior to decision time.
Okay, let's do that. So if there's anyone in the audience, applicant, opposition, those interested parties that would like to put anything else on the table, this would be your opportunity before the planning board deliberates.
Mr. Chairman, would this be an appropriate time for me to make some final comments on the draft decision?
This is Mr. Squires speaking, Al.
I'm sorry, yes. So the decision really isn't on the table yet. So I think certainly would like to hear your comments, but it might be just a whisker premature.
Okay, I can hold off until the appropriate time.
Let's, I would respectfully suggest that maybe the motion needs to be put on the table before we start talking about discussions.
Mr. Chairman, Maggie Hogan here.
Yes,
Thank you. So before the board begins, I want to make I want to put it on the record that I prepared a draft motion for this matter and also for another matter on the agenda this evening. I finished it in the wee hours of the morning, and I very mistakenly forwarded the draft motion for this matter to the attorney on the other matter. And Mr. Squires did not receive this draft motion until just shortly before, really moments before tonight's meeting began. So I would like to offer to him on the record my sincerest apologies for that oversight. It certainly was not intended. It was sent to all members of the board and the planning department, and I messed up and sent it to the wrong attorney. So I do apologize.
And Mr. Chairman, and to your solicitor, I'd say, it's not an issue. I know that you're a consummate professional, and so, I'm looking over it now, and as long as I have some time to comment on it, that's quite all right.
very good.
Thank you. That's very honorable.
Well, thank you both. I appreciate that. And Maggie, you also remind me that I also need to put something on the record here. This is probably the time. Let me exercise some latitude here. It was recently brought to my attention on this particular project that I was not in attendance during the March and April 2021 Planning Board meetings. My memory is engaged these days, and in all likelihood, I was before the Westerly Planning Board, if that decrepit memory serves me correctly. That said, once this was brought to my attention, I immediately reviewed the videos of both of those meetings, that's March 2021 and April 2021, to familiarize myself with the proceedings regarding this particular application. So I needed to put that on the record to be clear. And with that, let me continue with my offer to hear anyone else in the audience that wishes to put anything else on the table regarding this application.
So far, there are two members of the public. Do we want to go directly to them or to the applicant and then?
The offer was to anybody out there, so let's get to them.
All right. First member of the public, please state your name after I allow you to speak.
Hi, this is Eric Bibler on Woodville Road.
Go ahead.
Yeah, I'd like to, I've listened to the entire hearing, and there were some points that came up that were argued on both sides, but I didn't see that they were settled, and I just wanted to clarify. I want clarification from the planning board and or the planning solicitor as to how these issues are going to be resolved. As you will recall, the objectors to this project noted that the applicant has requested some waivers from the application requirements. Mr. Squires maintained that only the planning board has the power to grant those waivers. The administrative officer cannot grant them. I hope I'm representing these positions faithfully. This is my understanding. I believe Mr. Landry maintained that these waivers could be granted at some future date and didn't necessarily need to be granted now. But what I took away from that discussion, in my layman's understanding, I'm obviously not an attorney, was that while it may be possible for some of these requirements to be waived, I don't think the point was resolved as to whether or not it requires action on the part of the planning board. So I didn't hear the planning board take any action to grant these waivers. You know, if it's true that only the planning board can grant the waivers, then I would suggest that it would be appropriate that the planning board take that action rather than leaving this dispute hanging. More generally, you know, I just want to reiterate that something that we've said before, that we've been a point that we've been trying to make for the past 3 years in all of these solar projects. The planning board is granted an immense amount of authority to make determinations as to whether any land development project is consistent with the comprehensive plan in the opinion of the planning board. And if the members of the planning board took the time to revisit any decision for any planning board appeal, but specifically the one that the planning solicitor has circulated to all of you, Boone Street Presby versus Narragansett is a good example. If you read the standard of review for any appeal of any of your decisions for any land development project, particularly as relates to your findings of fact, that standard of review, that boilerplate language that is in every single one of these appeals, says that when the Board of Appeals, I'm reading from this Boone Street Presby decision, it dictates the Subdivision and Review Enabling Act of '92 dictates that when the Board of Appeals reviews the decision of a planning board, it shall not substitute its own judgment for that of the planning board or administrative, but must consider the issue upon the findings of fact and record of the planning board and administrative officer. And further down, it says, this is Judge Taft-Carter's decision, quoting the appropriate statutes, quote, "The court shall not substitute its judgment for that of the planning board as to the weight of the evidence on questions of fact." And then it goes on to list the areas where the court may overturn or remand the decision, and all of them have to do with unlawful procedure, errors of law, clearly erroneous expert testimony, and that kind of thing. So I don't know what decision you're going to make tonight. You haven't voted yet. I know you took a straw poll last month. The bottom line is, if the planning board agrees with the expert testimony that's been presented on behalf of the objectors and agrees with the comments of residents that don't want this project, and if the planning board doesn't believe this represents our collective vision for the future as expressed in the comprehensive plan, if you make an honest and good faith statement of that as a finding of fact that it's not consistent with the comprehensive plan, that will likely hold up. So in the context of all of that, in the context of the authority that you do have, simply refuse to approve this based on the scale and the scope and the environmental risk and the fact that it is wholly inconsistent with the state solar siting guidelines. The state wouldn't even buy the power from this plant if the developer wanted to sell it based on their recent RFP language. They're going to cut down approximately 100 acres or so of unfragmented forest to put in an 81-acre solar panel field. I'm at a loss after 3 years, going to dozens and dozens of meetings, listen to residents plead with you and the town council not to approve any more of these industrial power plants in our town, not to turn Hopkinton into Solar City. We've already got Alton Bradford Road, Maxon Hill, Skunk Hill's on the agenda. These are all massive projects. As you know, there has been almost no one that did not have an economic interest in any of these projects that has spoken in favor. I cannot, for the life of me, understand how the members of this planning board who have been witnesses to 3 years of this you have heard loud and clear from your constituents, who are supposed to be independent judges and not team players and agents of the town. I cannot fathom how any of you are going to put your name to an affirmative vote to approve an 81-acre solar project to clear cut unfragmented forest and say that that's consistent with the comprehensive plan. So I'm pleading with you that you have the authority to say no. You're not going to put planning board or the town in any kind of legal jeopardy. It's really between you and your conscience, whatever you think. And I also urge you not to place any value on the idea that you need to have a unanimous opinion or act as a team. You should all act individually and vote your consciences. So that's my plea to you tonight. Thank you.
Very good, thank you.
And I would like the point resolved, please. I would like the solicitor to comment on the waiver because the planning board has not taken a position.
Yep, we'll get to that. Next up.
Next member of the public, last four digits, 822. Please state your name for the record.
Hi, this is Joe Moreau. Good evening to everyone, first of all. I also am not an attorney either, and I won't try to be one. I will only talk about the Stone Ridge project. I will not mention any other projects. This property was rezoned in 1990. I don't know how long some of the abutters have lived in their homes, but it is obvious that the parties involved in this project have worked with our town and abutters to improve their proposal. The landowner could cut 100 acres of trees, could build commercial buildings, pave most of his land if he chose to do so. He had different plans in the beginning with a medical building, other buildings, etc. He decided against that mainly because of the residents' concern with traffic and other reasons. I've spoken to some residents in the area recently who are not opposed to this project. There was opposition from residents in the area when there was a proposal for the golf course, hotel, conference center, and so forth. I have a quote from our town's emailer who said that the planning board has every right to deny the project based upon a finding that the scope of the project is inconsistent with the comprehensive plan and based upon environmental concerns, citing the expert testimony provided by abutters. All I can say is really, wow, that is not what I read. I know there is a lot of information for the planning board to read on these projects. I pointed out in a recent email to members to read under the section materials from applicant, regulatory review analysis from the Pimentel Consulting. Those are the facts, they're not just opinions. I've heard testimony from true experts in their field at many, many meetings. With all due respect to abutters, I have never heard expert testimony provided by abutters. Companies like Crossman Engineering and Pimentel Consulting are the experts. Our town's emailer is certainly not an expert. Thank you for your time. I appreciate it.
Okay, very good, thank you.
Next member of the public, Colleen, please state your name for the record.
Hi, good evening. Can you hear me?
We can hear you a little bit. I think the connection might be a little bit slow.
Okay, I'll try to speak louder and clearly and slowly. Thank you.
Great.
Hi, good evening again. My name is Colleen Stephan on Lisa Lane. I'm in Hope Valley. I'm a resident of Hopkinton, and now I'm a passionate resident. I'm speaking to you from my heart. I wasn't going to pipe up this early, but I do feel that I need to tell you what I'm feeling. This type of massive development is inconsistent with the town's comprehensive plan. It denatures our best resources when I read it. The loss of over 100 acres of forests It's we are losing our forests and rural life. And so not only these tangible resources, but the intangible characteristics that make this project so offensive. And you can speak to expert testimony of those who are invested in the pros, but at the real heart, is this the goal of what we're trying to meet for this town? I just wanted to urge you to consider that when you're making a decision tonight, and to take the comprehensive plan and its goals for the current future projects at heart when you make these tough decisions tonight. So thank you.
Very good, thank you.
We don't have any other members of the public. Mr. Landry has raised his hand. You are unmuted, Mr. Landry, so you can speak at will.
Thank you, and thank you, Mr. Diorio. I just have a couple of very, very brief things to add before we conclude, at least things that aren't directly related to the draft decision. And the first, I'd just like to ask Mr. Cerenzia, I believe he's with us, just a couple of questions about the waiver issue that one of the public members waived. Mr. Cerenzia?
Yes, I'm here.
May I inquire, Mr. Chair?
Yes, go right ahead.
Thank you. There was some discussion at the last meeting about drainage calculations and the possible need for a waiver. Do I understand correctly that the original application included a waiver for the item of detailed drainage plan and computations, which I believe the town from Crossman Engineer indicated was unusual for the master plan level? But do I understand correctly that after the Crossman Engineering presented their comments, that our team did in fact provide an engineering plan related to drainage, including computations, correct?
That is correct.
And were those submittals consistent with a master plan type conceptual submission on the issue of drainage and calculations?
Yes.
Okay. And is it impractical, in your opinion, to have more detailed calculations or design parameters than were provided, given all of the variables that are not resolved at the master plan level, but at the preliminary plan level?
Yeah, in my experience, we've met or exceeded the master plan level, what is typically required at master plan level.
Okay, so do I state it correctly that we don't think we need a waiver at this point from that checklist requirement? We did receive a certification of completeness, but in the event that it was determined that a waiver was required by the board, it's our belief that that would be consistent with good planning practice, including the sequenced approach to approvals that goes along with a major land development project of this sort, where the concept is presented first and then the engineering occurs in detail thereafter.
That's correct.
All right, second issue, also very briefly, there was concern about dealing with large stones, boulders, and so forth that appear on the site. Have you worked with conditions in which boulders and rocks and outcroppings need to be managed in order to accommodate new development?
Yes. Yeah.
And what are some of the approaches that your firm has taken to managing that condition where it appears?
So I will just mention, in conjunction with our site engineering company, we also have a site excavation company that operated quarries locally in Westerly for a number of years, which have recently been sold. But we know a lot about moving rock, blasting ledge in certain instances, which is not required here. But moving large portions of rock and processing it on site. Our company still maintains portable crushers, and we do a lot of processing on site. So to get to your question with regards to what options there are, one option is to excavate those boulders where they need to be excavated and run them through a processing equipment and crushing and creating a processed material that can be used for fill and other uses such as subgrade roadways, driveways, anything that needs stable structural fill. And it's a very controlled material that we can create and use on site as part of the construction process. That would be a limited time frame and process of when that would be done, phasing in the project. The other option is to move those boulders and bury them in certain areas that require fill on site, larger excavations. The boulders could simply be buried, so they don't have to go through the process of being processed on site. Or we could use some of the rocks and boulders to line some of the paths and use them as barriers, or just kind of aesthetic features that follow some of the paths through the site. So there's a number of options that we can do, that we can implement, that will limit the amount of import of rock in and out of the site.
And another one would be to leave the rock in place in areas and work the solar array around it or over it, which is an option that's not available for most other types of commercial development, correct?
Yeah, most other commercial developments require excavation for utilities, underground utilities, foundations for buildings that quite frankly just require you to excavate. We have an opportunity here, and I should have mentioned, that is the first option we try to exercise, is limit the amount of grading on the site and just work with the grades on the site that we have because we can place solar panels with the undulation of the topography to a certain extent. I believe anywhere between, I think it maxes out between 15 and 20% slope, which is considerable. And we do have some slopes on this site, but the first thing we would try to do is work the land as least amount as possible that's from a cost effective and logistical standpoint, but also would be beneficial, so we don't have to move as much material, have as much activity, disturbing soils, that sort of thing, and processing on site as well. So yes, the first instance we would try to avoid at all costs.
And one more question: is the project engineering and landscaping team prepared to put together a detailed plan at the preliminary plan stage or in advance thereof that addresses just how after field analysis of the different areas of the site, how it proposes to crush, process, move, work around, or bury the stones that do appear together with a proposed construction timetable?
Yes, we would be willing to put that plan and present it as part of our preliminary or in advance of filing for a preliminary. Usually that comes in conjunction with our preliminary design, our detailed design. So it would come very close to that filing along with our state permitting.
Thank you, Mr. Transia. That's all I have of Mr. Transia. Mr. Chair, I do have one question of our landscape architect, Ashley Iannucci.
Mr. Chairman, I wonder, I would like to ask some questions of Mr. Cerenzia, and I could wait to a more appropriate time, or do it now, whatever the pleasure of the chair and the board is.
Would it be acceptable if Mr. Landry presents his, what I understand to be his last question or of his last witness, and then we can come to you you can question whatever witnesses you'd like?
Yes, thank you, Mr. Chairman.
Mr. Landry, proceed.
Thank you. Ashley Iannucci, are you with us?
She is. I'm going to promote her to panelist.
Thank you.
While I do that, Steve Cabral is in the audience. He did raise his hand, so if you'd like him to weigh in after this or after Mr. Squires speaks. I'm just letting you know that he's here. We also have another member of the public who raised their hand, so just to keep you apprised of
Appreciate that.
what's going on.
Steve, I recognize that you're out there, and we look forward to any input you might have right after, at the appropriate time.
This is Ashley, I'm here.
Ms. Iannucci, a question about buffering and screening of the Gregory property. There was some discussion last time about robust buffering and screening of that property that would be presented as part of the preliminary plan application. Since that meeting, have you actually put pen to paper and developed a concept of how the engineering and architectural team would approach effective buffering and screening of that property from the building on our site?
Yes, we have actually studied a couple different options and have selected what we feel is the best direction and created a plan to show that.
Okay, again, is there a possibility you could screen share that with us?
Yes, I would love to if I could get control of the share screen, if possible.
This is Talia. I've allowed all panelists to screen share, so you should be able to now.
Could everyone see this plan?
Yes.
So the concern, which we obviously took very, very seriously, was berming from the Gregory property, which is 10 Red Fox Lane. It's this property right here, if everyone can see my mouse. So the concern here was buffering to the new building and then the detention areas over here. So we studied a couple different options of how best to buffer that building and looked at if it was a concern at all. So we looked at potentially providing additional planting along the property lines. This is at a much lower elevation than the actual structure and would also require removing existing vegetation, which we found counterintuitive and probably not as effective. So the solution we came up with is to create a large bermed area here adjacent to the building. It would be at the same elevation as the building, and we can make that berm up to 8 to 10, almost 12 feet. And then on top of that, we can plant 12 or greater foot arborvitaes, spruce, pines, or evergreens that can create that buffer. So I think what you see here on this second elevation, you have almost 1,300 feet from the property to this proposed structure. A good portion of that is vegetated. And then since doing this diagram, we've also suggested that we'll add additional vegetation in here to create more of that buffering. And then you can also see this new proposed berm that's being planted here. So if you look all the way through where this little person is located on the adjacent property, 1,300 feet to the proposed structure, we feel like we can very successfully create a buffer that will eliminate any views to this new building. Can I answer any questions on that?
Just one more from me, whether it's this particular proposal or something else that gets worked through at the preliminary plan stage of review, are you confident that that building and the project can be successfully and effectively screened from the Gregory property?
Absolutely, and I think that's pretty clear with the sections and why we do them, but I'm very confident that we can buffer out this building.
Thank you. That's all I have, Mr. Chair.
Thank you very much. Before we go to the other folks, I just want to return to the waiver issue, if I may, Mr. Landry.
Yes.
I just want to be clear. This is like a new wrinkle. I don't think I heard this before. So let me just make sure I have this clear in my own mind. I'm sure other people will be grappling with the same question. So when the application was submitted, there was a waiver request for the stormwater issue. For some reason, you felt that that need not be presented at this time. Is that correct?
That's correct. It was more a deferral request than a waiver.
Understood. Yeah, understood. A question of timing. I understand.
Correct.
Now, subsequently, stormwater comps have in fact been submitted?
They've been submitted at a conceptual level.
Understood.
There were calculations and watershed maps and a whole stormwater packet that was submitted and reviewed by Crossman, recognizing that the preliminary plan stage would require something more detailed.
Understood. So is the waiver for that information still active?
Well, I don't think we need it, Mr. Chair, but, you know, to hedge our bets here, if somebody out of good measure, the board might consider that even if a waiver is required, the planning, under the statute regarding the planning waivers, good planning practice, reasonable, sound planning practice can give rise to a waiver and would certainly give rise to a deferral, which is all we're asking for. You know, the planning practice is set out in the process that we're following: conceptual review, preliminary review that has detailed engineering, and then final review. And we're following that sequence. And I think the thrust of what Mr. Terenzio was saying is that it's really not good planning to be guessing at things at the master plan stage and providing detailed calculations that aren't rooted in the real science that gets developed at the preliminary plan stage. It was testimony that the wetland edges and the whole wetland situation will come into focus much greater. There'll be site engineering about moving rocks and boulders, and you know, that all will have an impact on stormwater management. And we think it's consistent and contributory to good planning practice to do these things in a certain sequence and logical order. And that's what the process that we're going through was really built for.
I hear it, I understand it, I'm in favor of it. We're all cognizant of the fact that a concept submission is in fact just that. Nobody's asking, nobody's thinking about holding you to preliminary submission requirements at the master plan level. However, I'm sure you can appreciate that if we made the waiver issue go away, we will have satisfied another party. And that's just one less issue that the planning board has to grapple with. So once again, I just need to ask, is the waiver issue still legitimately active?
Mr. Chairman, I have some.
Just hold on. I'm looking for a response. Then we'll get to you.
Yeah, again, I don't think the waiver is necessary, but I do think out of an abundance of caution, the board should approve the waiver to the extent that it's necessary for all the reasons that we've just described.
Okay, very good. Thank you. That's the response I needed. I see Mr. Lampier with his hands up. I'm going to entertain his comment.
Yes, Mr. Chairman, Jim Lampier, Town Planner. I'd just like to expound a little bit on what Sergio and Mr. Landry said. I think that the planning board should rely on the testimony by Crossman Engineering. Sherensky and Associates did provide a report, Master Plan Stormwater Evaluation, dated March of 2021, and that was submitted under a cover letter that was dated March 26, 2021. And this report, stormwater report, contains the calculations that people are looking for. There's a HydroCAD analysis in here, there's mapping. It's all in a bound report that I believe the planning board has been presented in their April 7th packet. So, Steve Cabral from Crossman, I believe, has looked at this as well. I would, if I was the planning board member, I would ask Mr. Cabral if this meets the checklist requirements for the master plan and whether he thinks a waiver is necessary or not. Because in my view, I personally, as a planner, can't see where a waiver is even necessary. This is checklist item number 57 right here, so.
Mr.
I'm going to embrace that approach. I hear you. Again, we're going to get to you, so just hold on. Mr. Cabral, you out there?
He is indeed.
May I impose on you to, if you heard that last comment from Mr. Lampier, may I impose on you to elaborate for us?
He just has to unmute himself, and to do so, he'd press *6.
Oh, hello. Yes, this is Steve Cabral from Crossman Engineering. And the issue with the waiver actually is the result of a contradiction in the Hopkinton subdivision regulations. And the reason there's a contradiction is The definition of master plan and the overall master plan requirements are, as the chairman described and as the town planner described, the requirements for master plan are conceptual and more general in nature and do not require detailed design. But the contradiction comes about in checklist item 57, where there's a notation that if stormwater controls are proposed, detailed calculations and plans are required. So that's why in my most recent memo, I referred to the waiver. But the truth is the level of detail of the stormwater package that was submitted by the applicant does exceed what normally would be provided at the master plan level. So if the planning board does agree and concur that the intent of item 57 is to provide a level of detail that's more general in nature and not a final design, then I would agree that a waiver would not be needed. And I also agree that 100% of my experience over the past 40 years is that the detailed drainage plan does require detailed grading plans, and that's not performed until after the concept master plan is approved and it's performed, as everyone stated, at the preliminary stage.
Very good, thank you. Steve, that makes things at least much clearer for me. Appreciate that. Okay, I know that one of the attorneys was trying to get a word in edgewise, and I apologize.
Yes, Mr. Swart.
okay.
This would be your opportunity, sir.
Thank you, Mr. Chairman. I guess I'd like to start by asking a question of Mr. Cabral, if that's okay.
Certainly, go right ahead.
So, Mr. Cabral, I'd like to refer you to the May 6th memorandum from you to James Lanfear. You're familiar with that, correct?
Yeah.
And on page 2 of that memorandum, you have a section that lists checklist waivers, correct?
Yes.
And then in that section, you do reference a waiver required for master plan checklist item 57, which requires detailed drainage plans, correct?
Yeah.
Okay. And so when you drafted that memo, it was your conclusion at the time that a waiver was required for master plan checklist item 57, correct?
Yes, it all depends upon the town's interpretation of what's considered detailed at the master plan level, because as stated in the regulations, master plan level definition is clearly general in nature and not detailed. So as I stated earlier, there is a contradiction in the verbiage between the definition of master plan, the requirements of master plan, and that checklist item 57. And so when I prepared that memo, I based it on the exact wording of item 57, recognizing that the planning board would be the ones to make the final decision on what the intent of that checklist.
Okay, just to clarify, so I understand your reasoning that went into the memo. Following the language of item 57, which calls for detailed drainage plans, if you apply that language, that was why you concluded a waiver would be required? Is that correct?
Well, plus I had the applicant's request for a waiver, so at the time, yes. But I also recognize that it's not possible to prepare a detailed drainage plan without doing a detailed, grading plan and pretty much a final design package. So that's why, again, I stated there's a contradiction in checklist 57 versus the normal requirement. But yes, you are correct.
Okay. And so I guess the planning board certainly has the authority to revise prospectively their master plan checklist items and not ask for detailed drainage plans in the future, correct?
Oh, certainly.
Okay. All right.
or to clarify the intent.
Right. Okay. And Mr. Chairman, if I could just ask some questions of Mr. Sharenzia, I would appreciate that as well.
Yes, go forward.
Thank you. Mr. Sharenzia, when the application was originally filed, there was a waiver requested from item 57 requiring detailed drainage plans, correct?
Correct.
Okay. And although you've provided general concept level drainage plans, you haven't provided detailed drainage plans at this stage, is that correct?
It depends on what your definition of detailed is. I think they're sufficient for master plan level, and they're detailed to the master plan level, but no, they're not preliminary level.
Well, I mean, I guess the question, let me follow up on that, because, you know, you can look up the definition of detailed, and that would be, you know, having many details or facts, showing attention to detailed, you know, showing the facts that were the high level of specificity of facts in a drainage plan. The plans that you've submitted don't do that, correct?
At a master plan level, they do.
Let me switch on to a different topic. Well, then, if that's the case, why did you requested a waiver from this item, right?
I think we've established that the waiver is not required.
Okay. Well, let me switch on to something else. Mr. Sharenzia, what's your area of expertise?
I'm a professional engineer with I have a degree in civil engineering, and I'm a professional engineer.
Okay, and you testified on under questioning from Mr. Landry that to the extent a waiver is required, it should be granted because granting a waiver would be good planning practice, correct?
I don't recall.
So as you sit here now, you don't recall having an opinion on whether or not this would be good planning practice?
I don't recall making that statement. I'd have to go back to the record, but I can tell you at that point, we did not provide it, so the waiver was legitimized, but subsequently we got comment from the town engineer peer review, and we provided the additional detailed drainage calculations, so the waiver would not be warranted.
Okay, and last point, not being an expert planner, you wouldn't be qualified to provide an expert opinion on what a good good planning practice is, and that's ultimately up to the planning board to decide, correct?
I do weigh in on planning matters. I do have experience in planning per se of projects like this, but no, I'm not a planner. I'm a civil engineer.
Okay, and so I guess to the board, I could make some comments now on this issue. I'd also like to make some closing remarks at a certain point, which also would touch on some of the issues with the draft waiver. I'm sorry, with the draft motion. But I'll defer to the chair and to the board of when the appropriate time to make those comments are, whether to make them in separate times based on the issues addressed, or whether just to make them all at once now.
Very good, thank you. So if I could, first of all, is there anyone else in the audience?
Yes, there is still the member of the public who's wishing to speak.
Let's get to that person.
So I'm going to read off the last 4 digits. Once I do, I'm going to ask you to press *6, and I'm going to ask you to state your name for the record. The last 4 digits are 8453. Please press *6 to unmute yourself.
Hi, Kevin Gregory here, 10 Red Fox. Can everyone hear me?
Yes, go ahead, Mr. Gregory.
So, first of all, thank you for hearing me, and also I hate to backtrack on this subject, but you know I listened to the I listened to the, the solution to the issue that I'm having with this project. And I'm not even 100% sure where they come up with their math, as far as the distance from where this, this is in regard to the metal structure and the, and another feature, one of the retention ponds. As far as, the 1,300 foot number, I guess maybe from the building to my back door is 1,300 feet. But, early on, with one of these, one of the Zoom meetings, I suggested that maybe some of the members of the board can actually come to my property and take a look and see exactly what I'm referring to. But, unfortunately, nobody decided to take me up on that offer. But my issue is, first of all, it's significantly less than 1,300 feet. I mean, I physically measured where this is going to be, and I did get permission to go onto the property and do this. Well, I got permission to go onto the property, and one of the things I did was the actual dimension. So as far as dimensionally, it's 621 feet from the corner of the building to my property line. And my point of reference isn't going to only be from just looking out my back window of my house. My backyard is clear. And, when I did have a meeting, on my property with Walter Manning, and Sergio came by. And I mean, it's undeniable. I mean, I really have very little buffer from where my house is to where that corner, where that 621 feet mark is drawn on the plan. So, in as far as, plantings, I mean, everybody on the board and everybody that can hear this, we've all seen plantings around solar fields, and we've all seen how effective they are. And I don't know, I'm just not convinced that anybody is on my side with trying to rectify these issues. So, I mean, I don't know, I guess in also, from what I understand, this thing is going to happen whether or not I speak up or not. But I was just hoping that the board would, at least, view my concerns and maybe offer some, some more suggestions, or maybe even some viewings on the property to see where I'm coming from. But, and yeah, so I wait to hear a response.
Very good, thank you.
Okay.
We're clear out there? Maggie, could I impose on you for some guidance? So we have a, I know we have a draft decision for consideration. My question is, do we debate the components of the decision now, which seems a little out of step for me, or do I ask for a planning board member to make a motion in which the decision is elaborated upon, and then we debate it? Give me a little input.
Yeah, so I would suggest to you the latter, and again, that this draft decision is based upon the generalized discussion at the last meeting. And so then presumably one of the board members finds it sufficient enough to move it for consideration. And this is a motion to approve. Needs to be seconded, and then you can discuss it. And how you discuss it is of course up to all of you. I would note that in that decision, we do address this issue, if you will, of waiver. I believe that, quite frankly, at this stage of the game, what the board is really looking at, if at anything, would be a deferral of, as Mr. Landry indicated, of the further detailed drawings. I have to concur with the town's consulting engineer and the applicant's engineer that makes no sense for an applicant to submit detailed calculations on drainage at the conceptual master level stage of approval. It's not consistent with state law. And I would draw your attention to the section in your subdivision regulations that the opposing counsel has cited in some of the papers, that the board can't grant this unless unless the applicant show the literal enforcement would be impracticable and exact undue hardship. That section, I believe, speaks to a permanent waiver of addressing a subject. That's not what's before the board. this is, look, we're not saying that we're going to not deal with drainage calculations. We're saying it needs to come at the appropriate stage of review. So for purposes of, you know, that particular issue, if you find it a threshold issue, if you find it needs to be incorporated, we have some draft language in the decision on that matter. But I would call your attention to section 11.2, which has been cited by council in some of the papers.
Very good, thank you. So then my last question would be, my experience is that when we have a motion on the floor, it's been seconded, and the discussion ensues, typically that discussion is between the planning board members for the purpose of fleshing out and refining the ultimate decision. So in this particular instance, it appears that we're going to hear from other folks. And I guess I don't object to that, except that once we have that kind of discussion, we're back in the public hearing format. I don't really want to go there. So do I have the flexibility to curtail discussion outside of the planning board members?
Mr. Chairman, if I could volunteer, I would be willing to make my comments now before a motion is made, kind of give the final summation, let Mr. Landry close, like he'd like to, I'm sure he would like to make a couple final comments, and then I'd be happy not to make any comments while you debate.
So, no, don't misunderstand, please. It wasn't that it's not that I don't want to hear your comments. I simply want to, number one, hear them at the correct time. But if I could just get a consensus from both yourself and Mr. Landry that your commentary on the decision will be as brief as possible, I'll be more than happy.
So, Mr. Chairman, I would say that I have received an email from Mr. Landry with some proposed, you know, tweaking language of some of the paragraphs of the proposed decision. Mr. Squares, of course, has not had that opportunity due to my error. As you go through it, though, if we get to, you know, one of the sections where Mr. Landry has an issue, I could certainly present to you what he has sent to me in an email. If you wish to do it in that manner and then, you know, finalize this, then the way to do that would be to accept a motion to close the public hearing now, and then you would move into, it would just be solely board discussion and your legal counsel, me, discussing that with you. That would then short circuit any other additional folks from the public jumping in as to the language of the decision itself, which is probably a place you don't really want to go. They've already had the opportunity to opine this evening, and you've heard from them. So,
understood. How do I get Attorney Scores into the mix? Because I certainly want to afford him the same opportunity that Mr. Landry has had.
I understand.
I can make the comments now if you like, if that's premature, or I'd be happy to do whatever you prefer. If you want me to just make comments now, it may touch a little bit on the draft motion. Obviously, I haven't had a chance to review it in depth, but I can give you it would be a little bit of a closing, a little bit of a touch on the draft motion, and then, you know, I just leave you to it, if that makes sense.
Well, you know, again, now that I'm thinking about this, if Mr. Landry has had the opportunity to provide comments in advance of the motion being on the floor, I guess I'm prepared to allow you the same latitude. So why don't you go ahead and make your comments, and then my suggestion will be, it's only a public informational meeting. I don't really, Maggie, tell me if I'm incorrect. I don't have to close this. It's public information. It's not a public hearing. And then we can go to the motion.
Okay, thank you, Mr. Chairman. I can do that now if you like.
Yeah, let's do it.
Okay, so thank you. First, I'd like to thank the board for taking the time to consider this and to hear all the testimony, not only from the applicants, but from the abutters and from myself and the experts that we put on. I'd just like to touch on some discussion at the last meeting when the straw poll was being taken. And I recall there was some comment, not from all members, but from some members, that were hesitant to vote to approve the application, but they felt that they, for one reason or another, that they ought to approve the application. I'd just like to start by encouraging them to vote in accordance with your judgment on the application. And I paraphrase a quote from Edmund Burke on being a public official, which was, you don't owe anybody your vote. You don't owe it to anybody, not to me, not to Bill, not to anybody. But you do owe the public your judgment. So if you're in your judgment, you look at the standards you're supposed to apply, and you feel that one of them have not been met, I would just ask that you vote to deny on that basis. Now, I'll just briefly go over the points to discuss how you could deny this application. I know you have a draft motion which would approve, but you could vote to deny if in your judgment you felt that one of the elements were not met. And I'd just like to briefly go over where you could vote to deny it. The first required finding that you'd have to make is about consistency with the Hopkinton zoning ordinance. And here's where I'll touch on your draft motion a bit. So on page 9, paragraph 2, under the section titled Conclusions of Law, this is where that finding is in draft form submitted to you. And I'd note that the finding that is there states that the proposed development is consistent with the Hopkinton zoning ordinance. I'd pause to note that that is not consistent with the discussion up to this point, in that finding was addressed when there was a motion on estoppel, basically saying there was detrimental reliance, and therefore this concept of estoppel prevents us from deciding this on a blank slate, and therefore we're going to, that would preclude a negative finding on that. But I would note in your draft motion, it doesn't mention estoppel. In my opinion, and I argued it before, I won't hide it. I think although it would reflect your rationale in reaching a negative opinion on this to mention estoppel, on appeal, I would argue that estoppel doesn't apply. And I made that argument before. So if you were to stick with your rationale, you would put estoppel in there, and then I would argue both before you and on appeal that estoppel doesn't apply. But if you're not going to apply this estoppel, then I think you need to apply your independent judgment about whether or not this is consistent with the zoning ordinance. And that requires you to exercise your independent judgment about whether or not this is consistent with the commercial special zoning. And we've submitted a legal brief on this. We've submitted minutes from the Brayburn application where they proposed to change the zoning to commercial special. And it was perfectly clear, both the conditions on the ordinance that passed and the statements from the applicant at the time, that this commercial special zone change was tailored to only the Brayburn project. It didn't allow general commercial usage. So if you're not going to apply estoppel, I'd ask you to exercise your independent judgment on that point. And if you determine, yeah, you know what, despite the fact that, not your current solicitor, but prior solicitors have given, inconsistent opinions, and, prior building officials, when I look at this, there's no way to escape it. Commercial special was commercial special for Brayburn, and it's not just general commercial. So that's the first point where you could vote to deny if in your judgment you determine it should be denied. Now, if you don't want to touch that point, or in addition to that point, the second area where you could vote to deny is with regard to consistency with the comprehensive plan. Now, I know there was a comment made by the public that abutters did not present expert witnesses, but we did in fact present an expert planner, Peter Friedrichs. He is not only a professional planner currently, but he has a master's in planning, spent a long time acting as a planner. And his opinion, which he had the a written report to back this up, citing to the comprehensive plan. But his opinion was that because of the size and scope of this project, regardless of whether or not it's consistent with the zoning ordinance, it's not consistent with the comprehensive plan because the comprehensive plan did not contemplate utility scale solar, particularly when it has a substantial amount of residential residential zone property around it. And if you agree with that, if you agree with his point and you wanted to make a finding on that, you could simply vote that you do not think it's consistent with the comprehensive plan, and you can rely on and incorporate his testimony and his written report if in your judgment you feel it's not consistent. And I would say if it's appealed, reviewing courts are highly deferential to the board when there are matters of conflicting expert opinion. And here there's conflicting expert opinion. The applicant has one planning expert that says it is consistent. We have another that says it's inconsistent. If in your judgment you think our planner has the more persuasive case, in all likelihood that would be upheld on appeal. And then another point where you can vote to deny, either in tandem with the prior point or independently, we also submitted the testimony of an environmental expert, Linda Steer. And I think everyone on the board would recognize she's certainly qualified in the field to testify as an expert. And she opined that in this level of clear cutting, there's going to be a significant negative environmental impact. And so I don't think there's any way you could avoid it. And there's no way you could mitigate it later down the line on the final plan or on the preliminary plan. You know, when you're talking about this type of project in this size of unfragmented forest, when you clear cut, you're going to have a significant negative environmental impact. And if you agree with that, if you agree with her expert opinion, you could simply vote to deny on that basis and incorporate her expert testimony on that point and use that as a basis of your finding. Finally, there's the waiver issue. I feel like we've gone into that in some depth, but I would simply note, you know, this application was proposed as requiring a waiver because it required detailed drainage plans. There's been concerns about drainage, not only from in a butter. So, you know, but that's also another finding you can make. But I'd focus on the first three. First is zoning. The draft decision does not rely on estoppel. And if you're going to go on estoppel, I would ask that you put it in there so that that would allow us, and I'll be upfront about it, that would allow us to take the appeal and say, look, they relied on estoppel and we don't think estoppel applies. So please send it back and have them take a fresh look. But if you're not going to rely on estoppel, I'd ask you to take a fresh look at the zoning. And if you don't feel that commercial special supports this use, I'd ask you to deny on that basis. Second, if you don't feel that this is consistent with the comprehensive plan, you can rely on our expert, Peter Friedrichs, and incorporate his testimony and report and make a negative finding on that basis. And third, you could make a finding that it will have significant negative environmental impacts based on the testimony of our environmental expert, Linda Steer. One last point, you know, what's going to happen after you make your decision today? I would be willing to bet that no matter how you vote, this is going to be appealed. And so what happens when it's on appeal? It will go to the zoning board first. They'll take a deferential look to what you've decided on the facts and then take a fresh look on the law. And then from the zoning board, it will go to Superior Court. And at that point, all that will happen is either the zoning board and or the court will say, you know, either they got it right or they got it wrong. If they think you got it right, then your decision stands. If you got it wrong, then they'll either send it back to you to do it again, or they'll flip your decision. So really, there's nothing to be afraid of from an appeal. It will turn out however it turns out. So at the end of the day, I would just ask that if in your judgment, that you feel that this does not meet the standards that you're required to make, I'd ask that you make a negative finding. That's all I can ask you to do. I think that the public that you represent as a public official sitting on the planning board, I think, you know, they owe that independent judgment for each of you to exercise. And so I thank you again. I'd ask you to exercise that judgment, and good luck on your deliberations.
Very good, thank you. Okay, and with that,
We have a member of the public who just raised their hand. Would you like to entertain their comments, or would you like to go to Mr. Landry with his comments?
I'd like to go to Mr. Landry. I think the public had their opportunity and we're deeper into the decision-making process. Mr. Landry, closing comments?
Make it as concise as I can, Mr. Chair. There was nothing that Mr. Squires just covered that hasn't been said before. It's going to be hard for me to say anything that hasn't been said before. So I'll make it really simple. We've got a by right project here. It's a commercial area. By all accounts, what's proposed here would be benign in relation to other types of commercial development of many sorts that could occur by right, like this project on this site. Involve much more land disturbance. This site is over 250 acres, can be very effectively screened. The solar component is in about a third of that. The site is not zoned for open space or conservation or forest. It's zoned for commercial development. This is an applicant that's done everything the board has asked it to do. It took its time. It looked at all of the impacts that were of concern to the board, found a way to work with the Conservation Commission, did more than other applicants have done on solar projects or probably any other kinds of projects in Hopkinton. Worked hand in hand with the Conservation Commission that's most concerned about conservation impacts, worked a way to get the public on this site to establish the Narragansett Trail, made certain and demonstrated to you that this project can't even be seen from the Kenotchet Brook, much less adversely impact it. In fact, it'll benefit it by creating for some public access, walking access there, trail access there that doesn't exist today. They took every issue very, very seriously, including buffering and screening of the neighbors in a very emphatic way, and have committed to continue working hand in hand with the town and addressing all of their concerns at the preliminary plan stage. And it is important that we are not at the preliminary plan stage. We're at a concept stage right now, and these alleged environmental issues that no expert witness really addressed in any substance certainly are not even before the board at this master plan stage. That was one thing that their wetland wildlife expert said, that all of her testimony really relates to the preliminary plan stage of review. And so it's not over in terms of environmental impacts. The applicant is still burdened with continuing to establish that the science that's developed at the preliminary plan stage bears out the concept and our predictions about the concept that have been made in this stage of review. And finally, you know, most of the argument here by the objectors and opposing counsel is how, you know, the town's not going to get in big trouble somehow if they take a chance and deny this project. But obviously, this is not a fixed project or a done deal. We have no connections with the town. All we do is try to provide a good project, and that's what we've done. And what we've done is present a record. And the testimony, the overwhelming weight of the testimony that's been presented here by experts addressing real issues is that from a master plan conceptual point of view, every single one of the required criteria is satisfied and is satisfied in spades. the whole business about the zoning consistency and the comprehensive plan consistency. Mr. Pimentel's report is very extensive on those issues. The town has for more than 15 years regarded this site as one that's zoned for solar. That's been very consistent. Some very, very, very good law firms have all come to the same conclusion on that issue over a long period of time, and they did so because that conclusion happens to be correct. I thank you all for your patience and consideration throughout this process. I did have a couple of minor nits that Attorney Hogan did mention. I'm perfectly happy to leave that for the deliberative process where those can be simply noted as the board moves through the draft.
Okay, very good, thank you. So just out of curiosity, is that hand still up?
No.
Okay. All right, so planning board, it would be my suggestion at this point, we have a public informational meeting. It would not have been
The
my
hand
thought.
just went up.
All right.
And it went down again.
All right.
Of its own accord.
So I would
And
not have
it's
thought
up
that.
again. I'm sorry, Al.
I'm trying to give everybody a fair shot at this. I got a hand up. All right, let's go for it.
Mr. Rossi, please state your name for the record. After, you have to unmute yourself, but as you're on a computer, it's a button instead of a number.
Very much. My name's Jeff Rossi. I live at 313 Woodville Alton Road. I just want to comment in my opposition to this. I remember when the application was first made, I was at that meeting. Chairman Diorio couldn't understand how we went from it being zoned for a golf course, a special zoning, to now a huge solar farm, the largest that's going to be all around. It will dwarf the one that's on Bradford Road, and that's just hideous. I'm worried about the storm abatement. I know it's been, people say that it's adequate, but I remember the floods from 2011. That golf course was an absolute lake. 80 acres taken down, all of those trees are sponges. Where is that water gonna go? I don't believe they could make enough storm abatement to contain that water. I really prevail upon the planning board to resist granting a go-ahead on this. It's gonna have a very major effect. I appreciate you taking my hand. I raced to get home to come to this meeting. Thanks for hearing me out.
Okay, very good, thank you. I'm glad we were able to get you in the door.
I appreciate it.
All good? All right, so let me continue. We have a public informational meeting. It would not have been my thought that I need to close this, i.e. a public hearing, but on advice, I'm going to entertain a motion to close the public informational meeting for this project.
I'd like to make a motion that we close the public informational meeting.
I have a motion.
Second.
I have a second. Any further discussion on this motion?
Second.
Okay, hearing no discussion. All in favor? Diorio, yes.
Relowitz, yes.
Lindelof, yes.
Light, yes.
Shamshinia, yes.
Very good, thank you. Okay, so that brings us to decision-making time. Is there a board member that would like to put forth a motion, either for or against? Somebody got to do something.
This is Carolyn. We have Maggie's communication, her draft in front of us. Should we go through the entire thing, beginning with the findings of facts, etc.? I'll do it. I just want to know where to jump in.
Well, so my call is for a motion, one way or the other. And then, as you well know, there'll be a call for a second, and then there'll be a call for discussion, at which time the motion can be revised until we get to something that we can all agree upon. But we need a springboard.
Here we go. I move to approve RI 95 LLC's application for master plan for a major land development, Stone Ridge at Hopkinton, located at AP 11, Lot 47A, based on the following findings of fact and conclusions of law. Is everybody awake? Because this will take a while.
Take your time. We're all here.
Thanks. Our findings of fact are: number one, the subject property located off Palmer Circle, also known as Assessors Plat 11, Lot 47A, consisting of 251.96 acres, is zoned commercial special by virtue of a zoning amendment dated July 2nd, 1990, a copy of which is attached as Exhibit A. The zone change encompassed lots 47, 47A, 47D, 38, and 39 on Assessors Plat 11. Number two, on January 8, 2011, the Assistant Town Solicitor, Todd J. Romano, issued an opinion to Brad Ward, the Hopkinton Building and Zoning official. In that opinion, Attorney Romano advised that any of the uses permitted by right or by special use permit in a commercial district are applicable to Plat 11, Lot 47D. Romano opinion attached hereto as Exhibit B. In reliance on Assistant Solicitor Romano's January 8, 2011 opinion, the zoning official issued a letter to Mr. Roy Dubs, wherein he advised that the July 2nd, 1990 amendment permits not only those uses allowed in a commercial zone in 1990, referencing Article 2, Section 3, subsections 1 through 15 of the 1971 Code, as reprinted in 1989 with amendments, but also the mixed-use plan development as created by the amendment. Mr. Ward also found that Plat 11, Lot 47D may also be used as permitted by right in the zoning code, Chapter 134, adopted December 19, 1994, in a commercial zone. Ward letter attached hereto as Exhibit C. On April 4, 2018, the Hopkinton Planning Board granted development plan review approval for a photovoltaic solar energy system for Plat 11, Lot 47D, also known as Palmer Circle 1. This property was part of the subject property that received the zone change on July 2nd, 1990, referenced in paragraph 1 herein. Number 5, on May 1st, 2019, the Hopkinton Planning Board granted development plan review approval for a photovoltaic solar energy system for Plat 11, Lot 47, Palmer Circle 2 solar. This property was part of the subject property that received the zone change on July 2nd, 1990, referenced in paragraph 1 herein. Number 6, at the July 7th, 2021 hearing, Mr. Vincent Morano testified that he inquired with town officials as to whether the proposed use of PSES was a permitted use for the subject property. He stated that he was advised that the use was indeed permitted. He further stated that he actually delayed the closing on the property until after the town had issued a zoning certificate. He also testified that he had spent approximately $2 million to date on this project. Number 7, December 27th, 2019, the town's zoning official issued a zoning certificate for the property, and on December 31st, 2019, issued an amendment to the certificate indicating that use code 486, commercial solar installation, was a permitted use for the subject property. Building official supplement memo is attached as Exhibit D. On February 5th, 2020, the Planning Board conducted a pre-application meeting for the subject development. At that time, the applicant conceptually proposed 5 commercial buildings and a solar facility of approximately 148 acres. The applicant had not identified which commercial uses might be proposed and was seeking community feedback. On March 30th, 2020, the Hopkinton Town Solicitors issued a written opinion which concurred with prior legal opinions and zoning official opinions that the proposed solar array was a permitted use under zoning. See it, Exhibit E. Number 10, on June 15, 2020, RI 95 LLC, the applicant, submitted an application for master plan stage review. 11, after a resubmission to include missing materials and amendments, the applicant was certified complete on September 8, 2020. The resubmission indicated that the project would include a 102.6 acre solar array and one 50,000 square foot warehouse building. On October 7, 2020, the Planning Board conducted its first master plan public informational meeting. Natural Resources, Inc. completed a freshwater wetlands delineation report on the subject property. The report, dated December 23, 2019, was submitted as an exhibit for the October 7, 2020 public informational hearing. 14, the master plan review was continued through several additional hearings conducted on March 3rd, 2021, April 7th, 2021, May 5th, 2021, May 18th, 2021, and July 7th, 2021. 15, Mason and Associates, Inc. prepared a wildlife habitat assessment dated February 2021, submitted as an exhibit for the March 5th, 2021 public informational hearing. On March 19th, 2021, a revised report was prepared and submitted as an exhibit for the April 7th public informational meeting. Number 16, Ed Pimentel, a planning consultant, submitted an undated report addressing planning concerns and offering his opinions. This report was submitted as an exhibit for the March 3rd, 2021 public informational hearing. On March 19th, 2021, a revised report was prepared and submitted as an exhibit for the April 7th public informational meeting. On April 18th, 2021, a revised report was prepared and submitted as an exhibit for the May 5th, 2021 public informational meeting. Number 17, a landscape plan was prepared by Traverse Landscape Architects. This report was submitted as an exhibit for the March 3rd, 2021 public informational hearing. In April 2021, a revised landscape plan was submitted. On March 2nd, 2021, the Wood Pawcatuck Wild and Scenic Rivers Stewardship Council issued a letter questioning the appropriateness of elements of the proposed plan and offering mitigation measures should the planning board approve the master plan. 19, Aberdeen Environmental Services, Inc. conducted 40 soil examinations and submitted a report dated January 29th, 2021. Number 20, Sherenzia and Associates prepared a stormwater evaluation dated March 2021. This report was submitted as an exhibit for the April 7th, 2021 public informational hearing. 21, the ESS Group prepared a noise impact assessment dated April 21st, 2021. This report was submitted as an exhibit for the May 5th, 2021 public informational hearing. Number 22, on April 7th, 2021, the Hopkinton Conservation Commission issued a letter to the planning board addressing the following topics: open space, groundwater, solar performance enhancements, trails, fencing, ceremonial stone landscapes, stone walls, easements, wildlife, and warehouse. On April 15th, 2021, Hopkinton Police Chief David S. Palmer sent an email to the applicant's representative indicating that the police department expected no traffic problems with the project. Number 24, the Hope Valley, Wyoming Fire District Fire Marshal issued a letter indicating no problems with the plans at the present time and stated that a more in-depth review would take place as permitting progressed. 25, the Narragansett chapter of the Appalachian Mountain Club submitted a letter on April 23rd, 2021, outlining its purposes and its involvement with the applicant and efforts to restore the Narragansett Trail, a 44-mile-long hiking trail. The letter identified that a section of the well-established Narragansett Trail, flanked on both sides by stone walls and other significant features, such as large rock piles and stone foundations, had been identified for preservation. As a result of consultations with representatives of the Hopkinton Conservation Commission and the Appalachian Mountain Club, the applicant revised its plans in the spring of 2021. The trail is proposed for partial relocation, but will avoid wetlands and wetland buffers. Number 26, as amended and reduced, the project consists of an approximately 81-acre solar array and one 15,000 square foot building dedicated to storage of the solar-related materials and battery storage. 27, a solar array is almost entirely a passive use that is visited only occasionally for maintenance purposes, requires little or nothing in the way of municipal services, such as trash removal, police, fire, or other public safety services. There will be no adverse fiscal impact to the town for school-age children. The battery storage building will be minimally occupied at any one time with only 4 to 5 employees. The solar array may be assessed for tangible property tax purposes at $5 per kilowatt, in addition to the assessed valuation of the underlying real estate and the battery storage building. At the May 1st, 2021 meeting, prior to commencing the evidentiary hearing on the final master plan, the board found that the proposed solar use was in fact a permitted use, citing the town's long-standing interpretation of the 1990 zoning amendment, prior approvals for the solar on land that was also part of the 1990 zoning amendment, and the applicant's reliance on the town's repeated interpretations. 29, At the May 5th, 2021 meeting, the applicant presented testimony from Sergio Cerenzia, professional engineer, Ashley Iannucci, Julian, landscape architect, Edward Pimentel, land use planner, consultant, Joseph McHugh, wildlife biologist, Scott Rabideau, wetlands biologist, Ed Avizinas, soil and scientist and wetland scientist, Mike Ernsting, environmental engineer, and Vince Morano, owner. 30, Mr. Chianzia described the overall development, including the reduction of the proposed building from 50,000 square feet to 15,000 square feet, the existing natural features and the areas for development and preservation, the extensive discussion and cooperation between the applicant, the Hopkinton Conservation Commission, and the Appalachian Mountain Club, and the requirement for future RIDEM approvals, including stormwater mitigation. He indicated that impacts would need to be mitigated to the Conachit Brook. He stated that the applicant was not seeking waivers from any of the requirements of the PSCS ordinance. He stated that the applicant had submitted a lighting plan that was dark sky compliant as required. Mr. Cerenzia's testimony was unrebutted. 31, Ms. Iannucci Julian described landscape buffering for the new trail system and abutters, the bioretention areas, and the stormwater management areas and views. She explained that the majority of the site is buffered by wetlands and that with the plan revision reducing the solar energy by 20 or so acres, a good portion of the southern site was saved. She indicated that although 100-foot setback is being maintained, some of the trees in there were deciduous, so they were proposing to add additional drought-tolerant evergreen screening. Further, she stated that the screening was proposed to buffer the trail and the hikers from seeing the solar array. The retention areas were designed as bioretention areas to be planted with combinations of wet mix that all native plant materials, combinations of grasses, fescues, sedges, wildflowers, and native New England species. All distributed areas will be seeded with a wildflower mix. There will be between 800 and 1,000 feet of forested buffer to block, 1,000 feet of forested buffer to the brook. Ms. Iannucci Julian's testimony was unrebutted. 32, Mr. Pimentel testified that he had submitted an extensive report. He referenced the fact that other uses could use a significantly greater portion of the subject property and would have far higher impacts as permanent structures. He maintained that the community will benefit from the tax base while assuring the property owner rights to use his property. Yet, the proposal takes into consideration the concerns of neighbors and other pertinent agencies. Number 33, Mr. McHugh testified as to the potential wildlife impacts from the site disturbance and mitigating measures. The first mitigation was a reduction of the development by 20 acres and the preservation of substantial portion of stone walls by relocation and stone features. He testified that the project is avoiding areas of steep slope with large boulders that provide denning habitat for mammals such as foxes and coyotes despite disturbance. He stated that the proposed fence, which will be elevated 6 inches off the ground, will allow small animals to traverse habitat freely. He also stated that whenever he had a suggestion for the project team, they responded without hesitation. 34, Mr. Rabideau explained that his firm delineated the wetlands on the entire 252-acre site. and that took 5 days to complete. He stated that the next step would be to submit to the Rhode Island DEM. His testimony was unrebutted. Ed Aldezinas testified that he conducted approximately 40 evaluations on the property so that the engineers could design the bioretention areas which will attenuate, treat, and promote infiltration of any stormwater generated from the site. Those designs are based on soil properties. His testimony was unrebutted. 36, Mr. Ersling testified that the sound levels for this type of equipment for solar project is extremely low. This project will have pad-mounted utility scale inverters and transformers. He stated that the maximum decibels was 33 at the property line, not accounting for any additional vegetation. He described the noise as background and essential, imperceptible. His testimony was unrebutted. 37, Mr. Murano testified that he called the town to find out the zoning before he purchased the property with the original intent of developing it as a medical facility. He explained his background as having developed the Morrison Medical Center with 550 square feet of space for the Atlantic Health Group. He originally, though that the Rhode Island aging population, this would be a needed facility. In later development, he thought it might develop 900,000 square feet. He testified that someone in the town suggested he pursue solar instead. He stated that he had negotiated a 25-year lease with an energy company with 2 10-year options to renew. His testimony was unrebutted. The proposal now includes just one 15,000 square foot building. 38, at the May 19th, 2021 meeting, the abutters presented 2 witnesses, Peter Friedrich, a planning consultant, and Linda Steer, a wetlands and wildlife biologist. 39, Mr. Friedrich testified that although the reduction in the size of the proposed array was an improvement, in his subjective opinion, the application still was not consistent with the comprehensive plan in several areas. 40, Ms. Deere was accepted as an expert in wetlands and wildlife. She concluded that the proposed project would have a significant impact on the wildlife habitat. She described the area as a 500-acre unfragmented forest in a 2015 amendment to the Rhode Island Wildlife Action Plan. She explained that birds such as scarlet tanagers, wood thrush, a number of warbles need these large unfragmented pieces for nesting habitat. She noted that a portion of the site has a groundwater recharge area and wellhead area nearby. She noted that the Nature Conservancy has identified the site as a climate corridor designed to protect carbon sinks. She stated that there would be loss of wildlife habitat. She concluded that this loss of habitat, approximately 100 acres, would have a very large, significant impact. On cross-examination, she acknowledged that she was not aware of the mitigation testimony provided by the applicant's witnesses. She further understood that RIDEM review process had not yet begun because that doesn't occur at the master stage of review. Number 41, on May 19, 2021, a letter of concern about the proximity of the proposed build to an abutting property owner was submitted by legal counsel. 42, the line of view between the proposed building and the abutting property owners extends several hundred feet. 43, at the July 7th, 2021 meeting, the applicant indicated that it met with the abutting property owner and expressed its commitment to provide robust screening, buffering, including, if necessary, a heavily vegetated berm. Number 44, on June 9th, 2021, 4 planning board members in 2 separate groups 2, visited the site with a representative of the applicant's engineering firm. The planning board site walks reveal that there are a substantial amount of massive boulders throughout the acreage proposed for development. 45, at the July 7th, 2021 meeting, the applicant's engineer, Mr. Sherenzia, described the plans for dealing with the many boulders. He explained that most of the boulders observed during the site walk had been excavated during the soil evaluation process, and that he did not anticipate a substantial increase in the number of boulders. Wow, what's that?
It's thunder right over the town council chambers.
I've got thunder over here too. Number 45. Oh, did I do that? At the July 7th, 2020 meeting, the applicant's engineer described the plans for dealing with the many boulders. I read that one. Number 46. There is an historic cemetery, Warden Lot HP 043, located on the property. Extensive stone walls and a portion of hiking trail, the Narragansett Trail. There are 53.23 acres of wetlands, 22.63 acres of perimeter and riverbank wetlands, and 176.2 acres of upland. 47, Crossman Engineering served as engineering consultant to the town for peer review of the project. Crossman issued multiple memoranda throughout the course of the master plan review process. Crossman identified specifically that the drainage plan submitted at this stage of review was sufficient for review and that significantly greater detailed plans come at the preliminary stage of review. 48, the applicant has agreed to recreate the Narragansett Trail over the site and to allow public access to the site for recreational hiking. The public presently has no rights to enter the property as it is privately owned. 49, at the July 7th, 2021 meeting, Mr. Sherenzia testified that to install the solar arrays, drilling can be done right into the surface and subsurface rocks and boulders so that many of them will not require removal. There is no ledge site that would require blasting. The application was formally opposed by abutting property owners represented by counsel. Competing legal memorandum were submitted by the applicant and the abutters about a variety of issues. 51, the board accepted oral and written comments from multiple members of the public during the course of the proceedings. 52, the town of Hopkinton is inadequately staffed to provide sufficient regular oversight of the proposed construction to ensure compliance with the town's regulations and ordinances. Board member Prelwitz offered to serve as a volunteer to assist the town in reviewing the construction. 53, the town has imposed work time restrictions for other solar array projects which limit construction to weekdays from 8 a.m. to 5 p.m. 54, Mr. Vincent Marano testified at the July 7th, 2021 hearing and expressed his intent to work with the town as much as possible with the goal of making this project a model solar project. He pledged his commitment to do what was necessary to provide adequate screening of the project from the abutters and agreed to work with the town to ensure sufficient oversight in the eventual construction process. 55, the solar array is anticipated to be a temporary, albeit long-term temporary use of the parcel of approximately 25 to 30 or 40 years. 56, A solar array decommissioning plan was not submitted at the master stage of review, but will be required at preliminary. Anyone need a break? Conclusions of law. Number one, the proposed development is consistent with the following components of the comprehensive community plan. A, natural resources goal N5, promoting energy self-sufficiency for Hopkinton and Rhode Island. B, policy con 7, to concentrate near exits 1 and 2 of I-95. C, economic development goal number 1, to provide for the expansion of the town's tax base by encouraging development of new and existing light industrial and office commercial business. D, public services and facilities goal 17, to encourage renewable energy projects in the private sector. Natural resources goal 1, to preserve and protect and conserve natural resources. Number 2, the proposed development is consistent with the Hopkinton zoning ordinance and the town's long-held and relied upon interpretation of the July 1990 zone change, and is the same use that the town has already approved for 2 prior applications for solar arrays on land that was part of the 1990 zone change. The proposed structures and buildings comply with the dimensional regulations of the ordinance, and no variances or waivers are required. Number 3, at present there appears to be sufficient assurances that there will be no significant negative environmental impacts from the proposed development. However, this issue is one that will be addressed in detail at the preliminary stage of review, and the board reserves all rights to make a final determination on this issue and to impose additional conditions, all at the preliminary stage of review. Number 4, the proposed land developments will have adequate and permanent physical access to all of a public street. Number 5, the proposed development provides for safe circulation of pedestrian and vehicular traffic, for surface water runoff control, for suitable building sites, and for preservation of natural, historical, and cultural features that contribute to the attractiveness of the community, with required conditions of approval. Specifically, the project has been substantially reduced in scope. The project is unlikely to be visible to any degree by any surrounding residential property. The applicant has committed to substantial clearing to one abutting property owner that otherwise might have a glimpse of a storage building. Several stone foundations and features will be preserved, and the Narragansett Trail will be preserved in part and relocated in part. Number 6, at present, there appears to be sufficient assurances that the design and location of streets, building lots, utilities, drainage improvements, and other improvements in the proposed development minimize flooding and soil erosion with required conditions of approval. However, this issue is one that will be addressed in further detail at preliminary plan stage of review, and the board reserves all rights to make a final determination on the issue and to impose additional conditions, all at the preliminary stage of review. Number 7, the review of the project as a major land development project requiring master plan, preliminary plan, and final plan stages of review, as opposed to the singular development plan review, was appropriate because the project, as originally submitted, was not simply a photovoltaic solar energy system, but rather included other commercial uses and structures. In addition, reviewing the project as 3 stages allows the planning board has extended period of time for a graduated level of review consistent with the needs of the town. The order reads as follows. Number 1, RI 95 LLC's application for waivers from any unsatisfied master plan checklist items is hereby approved for this stage of review only. The applicant is not seeking and the board is not waiving any requirements for ultimate development plan approval, and all other aspects of existing drainage, circulation, relationship of buildings to each other, landscaping, buffering, and lighting will be reviewed and determined at the preliminary stage of review. Number 2, RI 95 LLC's application for master plan is hereby approved with the following conditions of approval to be developed at the preliminary plan stage of review. A, the applicant is directed to prepare a detailed plan for the preliminary stage of review that addresses how it plans to crush, process boulders, rocks, and other materials on site together with a proposed construction timetable. B, the applicant is directed to prepare a plan for the preliminary stage of review that stage adequate expenses to provide supervisory personnel to observe and ensure compliance with the proposed construction. C, the applicant shall submit a dedicated access easement to the historical cemetery for the preliminary stage of review. D, the applicant shall address the Wood Pawcatuck Scenic Rivers Council's recommendations and incorporate as many of its recommendations as possible at the preliminary stage of review. E, the applicant shall present a detailed plan and supporting legal documents for the preliminary stage of review that will identify, explain, and confirm Appalachian Mountain Club's future role in maintaining the rerouted Narragansett Trail. F, the applicant shall submit a decommissioning plan at the preliminary stage of review. G, the applicant shall include pollinator habitat in the landscaping plan at the preliminary stage of review and shall develop a plan that requires a minimal amount of fertilization or other chemical maintenance. H, the applicant shall, for the preliminary stage of review, cooperatively develop a plan of robust screening for the abutting property owners that might otherwise have a view of the proposed solar array or building. I, the applicant shall anticipate and expect that the planning board will, at the preliminary stage of review, contemplate the imposition of work time restrictions to be consistent with the conditions imposed on other solar arrays, with construction limited Monday through Friday, 8 a.m. to 5. Finally, J, the applicant shall anticipate and expect that the planning board will, at the preliminary stage of review, consider the imposition of a performance bond to ensure strict compliance with the terms of any approval, especially in regards to the amount and relocation of tree cutting and on-site topsoil preservation. And at that, we are ready for the next step. Do we have a second?
This is Ron. I'll second.
Hold on, did we lose the town?
I think we lost the
I think
town,
we did.
yes.
I think we lost the town.
They got
So
hit by
everybody stand by. Let me call Ashley. Ashley, I mean, jeez. Sorry.
Are we gonna have to reread some of that?
No, because I think this is, it's still recording on my screen anyway, it says. So we'll see. It says, I got a message from Al, tech issues in progress, a mess. stand by. I'm going to go on mute.
Good job, Carolyn, anyway.
Hey, not bad for after 5.
Tremendous.
Thank you for that. That was nice.
Thunderstorms.
Okay, folks out there in the world, I have Al Diorio on the telephone. They had a very large crack over the town hall and they do not have communications. I've explained to Al that we can all still hear and see each other out here and that it appears that the video is still recording. Talia is able to confirm that she gets a message that it's recording, but they cannot see or hear us. So Al, you wanna jump in there? Hang on. Let me turn up the volume. I don't know if they'll be able to hear you, but try it. Nope, it's too, wait a minute, I didn't put you on speaker, that explains it. Okay, there we go.
All right, so once again, I appreciate the alternative arrangement here. our world blew up with a lightning flash in the vicinity. So we are not live anymore. Apparently you folks can communicate with each other, and that's great, but we're out of the loop. So Maggie and I just chatted briefly. We're thinking maybe we give it 10 minutes, 15 minutes tops. I'm thinking 8:20. If we can't get our act together on this end, I'm afraid that we're going to have to adjourn the meeting and move to our next regularly scheduled meeting.
So, Madam Solicitor, I would just suggest that you do have an alternate and a motion on the floor. I would ask if you can't get the technical issues together, you know, maybe it would be appropriate to have the alternate vote.
I don't think that's an appropriate option under the circumstances. I don't know, quite honestly, whether or not the rest of the public is excluded from this meeting. I am concerned with the open meetings component of things. If I've got the chair who's now precluded from chairing the meeting, I'm not comfortable with that. So I would suggest that we do what the chair has recommended, and that is let's wait for 15 minutes. It may be that the technical issues are resolved. They do have a new fellow for the town that could be called. He came in, if you recall, the last meeting. So let's give it a 15-minute break here and see if we can't put our heads together and figure out the plan.
Yep, Maggie, let folks know that Tech Wizard is, we're in communication with him, but you know, he can only do so much.
Okay, all right, so we are gonna be in recess now until 8:25.
Okay, good. Will you call me back at that time?
Yes, I'll probably call you before then.
If we don't communicate.
Yep, all right. Thank
Very
you.
good, thank you.
Everybody can go ahead and mute and turn off your cameras for the moment, I guess.
Will we be required to re-sign in?
Ron, I'm just leaving my phone on.
Yeah, I'm going to leave mine on too.
Yes, that's fine. I just meant for those who wanted to mute themselves. You didn't have to sign off. You just, it's up to you, because if you don't mute yourselves, you start talking to your husband, your wife, we're going to hear you.
Hey, Maggie?
Yes.
I was...
You're on the public right now.
Oh.
So you know.
Oh, well, I had the pleasure of listening in on the zoning board meeting recently, and I just wanted to thank you for your contributions. Great job.
Thank you.
But who am I to judge? I'm not a lawyer, and I don't play one on TV.
We're back.
I just took a peek at the weather radar. It looks like the big part of the storm is gone. So hopefully
Hey,
these guys will be...
Are folks out there? Al Diorio.
Yeah.
Wow.
You're safe, Al.
Yes, we're finally back.
Yes, we have life and limb.
I'm going to ask, so because we were no longer on, I'm wondering if any of that was recorded while we were off.
Maggie indicated that she got a note or was able to perceive that the meeting was still being recorded.
Okay, so that answers my question.
I would not know that, but.
Yeah, so let me just jump in for a moment. I'm fielding a number of messages here from a variety of the parties here. In our screens out here in cyber world, we can see the record button blinking, which suggests to us that it is being recorded. I'm going to assume that it is.
Okay.
I do note that there was a Tracy Shepherd reporter who's in the Zoom meeting. I assume she's with one of the applicant or the objector. Who's she with? Tracy, I just saw your volume come on.
Hi, Maggie. Yes, I'm with Mr. Landry.
Okay, great. So in the event that the local recording has failed, there is a level of recording of the meeting, so that's helpful. But we have already, we're going to have to need to be in recess to 8:25 because that's what we said, and members of the public may have gone to do something else with the plans of coming back to the table at 8:25. So everybody take a break and hopefully this stays on.
Okay, noted.
Hi, can I interrupt for a second?
Yes, Jeff, we're on recess for the next 10 minutes.
Okay, this is Jeff Burnett, the IT director from Hopkinton. I actually just ran home. The meeting is being recorded. The town hall did lose the internet to get home, have the town hall rejoin. The town hall is having a problem with its internet connection. It is unstable right now. There is nothing that I can do to stabilize it at its current time. I just did look at our internet service provider. The provider in the area is having issues. So this could happen again. I will walk Talia through what she could do to reconnect, but it could happen again. So I'm going to attempt to show her what I just did. So I just wanted to let you guys know that.
Thank you.
I have participated in a meeting last year that was done by candlelight at my house. It's so romantic.
I hope that not to happen. I hope that not to happen because I just ran home from having dinner.
Aww.
Carolyn, was that a meeting or a seance?
Was it a meeting or a what?
Seance.
Well, you know, with the planning board, you could consider
To our
it
tech,
both.
to our tech wizard, I want you to. Our tech wizard, we greatly appreciate your efforts.
We do. Thank you, Jeff.
Problem. I was only a couple minutes down the road, so.
I noticed he wasn't wearing a Batman cape, though.
No. So let me see if I can walk you through this, Talia.
Yeah.
Talia, call me back on that cell phone number that I gave you.
All right. Mm-hmm. Yeah. I have to pull up the screen. Oh, did you minimize it? Okay, so I'm unmuting myself, starting the video again.
Ready to rock?
People are coming back in dribs.
Okay.
Slowly.
So if you can hear me out there, it's 8:25, and we agreed we'd return to business. So as people begin to get back on board, I think the first order of business here is to, Maggie, maybe I could impose on you to catch us up to what the hell transpired while we were out of commission.
So Carolyn Light completed reading the draft decision, and she called for a second in your absence, and Ron Prowitz seconded the motion, and that's where everything stopped.
Okay, so we have a motion, we have a second.
Yes.
Time to call for a discussion on the motion. First of all, I'll look at Talia here. Do you think everybody's back?
No. I know definitively that not everyone is back. Mr. Landry has not turned his camera back on, and neither has Sergio. Mr. Landry just turned it on, so I'm assuming he was just waiting at his desk to turn it back on. So.
Understood. Okay. I'm going to presume the principal players are back on board. So again, I understand we had a completion of the motion. We had a second. Time for discussion on the motion.
Hey, Keith here. Can I hear me? Am I muted or unmuted?
We can hear you, Keith.
Oh, great. So it is not the most eloquent of speakers, but I tried to voice some opinion in our last meeting, and I think I've got a better mindset of how to describe what I'm thinking. And really, you know, there's some debate about findings of fact number 39, size and scope, number 40, whether there is or isn't negative impact on the environment. And I guess those are some things that, especially the environmental impact, we wouldn't know for years to come. But what I guess the underlying thing for me, and number 55, the solar array is anticipated to be a temporary, albeit long-term temporary. I think the word temporary.
I'm sorry. This is the court reporter. Mr. Lindelo, could you speak a little louder into the mic? If that.
Yeah.
It's okay. Thank you. I appreciate it.
Yeah, I'm taking myself off speaker. So I just want to talk about item 55 under findings of fact, where it mentions that it's a known fact that the solar array is anticipated to be a temporary, in the words of item 55, albeit long-term temporary. But I would argue that it's really a short-term use of the I guess the project. And if we focus on, and maybe my assumptions are wrong, but solar is in place to kind of take the place of our current energy sources. And then, you know, if a solar project only lasts 20 to 25 years, or maybe in this case of 40 years, then I guess what we're setting ourselves up for in the future is, what do we do after that? How do we replace all these, especially these large-scale solar projects? What are the future generations, or any of us that are around back then, where are we turning to replace what we're replacing our current energy source with? And to me, it just creates a big unknown. And I don't know that, for me, it's not something that, it sounds like we're taking a big risk where we're going to turn in another direction, and then in 25 to 40 years, we're going to have to turn back another direction, either go back to what we have now or who knows what the future brings to us. So that's the underlying concern where I'm having trouble supporting not only this project, but many other solar projects, because there's just great unknown out there. That it's new and some of it's attractive. That, you know, in concept, we're going to get rid of fossil fuels and have a new renewable energy source, but then it goes away, and then what do we do? So that's the underlying fault with me. I just doesn't make sense that we're going to enact something for 20 years and then have to come up with another issue, or our predecessors, or I mean, people after us are going to have to figure it out. So that's my problem.
Understood. Thank you, Keith.
This is Emily. I'd like to just offer some opinions. I prepared my thoughts ahead of time, so I would not ramble too much. After reading the compilation of facts and the resulting conclusions of law on the findings required of us to make, I found that several facts prevent me personally from making some of the required findings. And I want to explain those just real briefly. The first finding that I'm unable to make is on consistency with the comprehensive plan, and the second is on environmental impact. These are intertwined in my mind because of the broad scale of this project. The abutters witness, Peter Friedrichs, reminded us that the comprehensive plan states in the public services and facilities section, recommendation 17 on page 123, quote, adopt regulations that encourage small-scale renewable energy installations, end quote. There are no further recommendations in the comprehensive plan regarding the size or siting of renewable energy installations, only the intention to encourage small-scale installations. Obviously, and as the applicant's planning expert, Mr. Pimentel, has pointed out, the words small and large are subjective, but this project would be the largest in town by about 20%, 81 acres versus Maxon Hill, which is about 68 acres. A project of this size is simply not consistent with the town's intentions as expressed in our comprehensive plan on page 123. Further, I acknowledge that every development will have some degree of negative environmental impact, and most of our land use decisions involve balancing the positives with the negatives. We heard testimony from Ms. Linda Steer about the negative environmental impacts of this project, including the fragmentation of a 500-acre contiguous forest. I'll note that from my own research on the Rhode Island DEM mapping website, this area of contiguous forest is identified as approximately 1,055 acres. In addition, Ms. Steer noted disturbance to a recognized climate corridor, which provides value as a carbon sink and protects connectivity of the landscape, as well as disturbance to a groundwater recharge area and losses of wildlife habitat. We heard testimony, expert testimony from Ms. Elaine Calderon from the Wild and Scenic Rivers Stewardship Council, who noted the potential disturbance of this development to the natural hydrology of the area. The applicant's expert testimony described mitigation measures taken by the applicant, which addressed some elements of wildlife habitat, reducing the overall footprint of required clearing by 20 acres and preserving stone structures, but have not adequately addressed negative impacts caused by clearing over 80 acres of forest to the hydrology of the watershed or to groundwater, which are natural resources that belong to all Hopkinton residents and provide critical infrastructure. The stated mitigation measures are efforts in the right direction, but not enough, in my opinion, to allow me to agree that there will be no significant environmental impacts resulting from this project.
Okay, thank you. Any other comments or thoughts?
Yeah, it's Keith again. I just want to remind, well, it was Carolyn actually, wasn't it one of these sessions a couple of, a year or so ago where you had your, was it your niece, or I forget what the young lady's name was, but she spoke so eloquently about the environmental impact that it kind of moved us all to vote no on that particular project. And I would say that those same sentiments, if she was here, she'd be saying the same thing about this one. Hopefully you can agree with that, Carolyn.
Absolutely. She's an advocate for maintaining the existing conditions everywhere. I am too. None of that has changed. In my personal position right now, this is a project that can happen because there have been extreme measures taken to take into account the disruption that's going to occur. And for those of you who don't know, this is down the street from me. So it is sensitive to my neighborhood and what I perceive to be the grounds that I like to walk around on and what I like to see. And I'll be honest with you guys, my granddaughter Liliana and I trespassed on that property. And we had a great time. And we had great talks about the things that we were seeing there. But inevitably, because of the way this property is zoned, there has to be some kind of a give. And in my mind, in my position, and in my discussions with my granddaughter, I would rather have a passive neighbor that's gone above and beyond to address the conditions of the Appalachian Trail, the Narragansett Trail, the historical landmarks that are buried in that property. This is, quite honestly, I think if every project development approached all of these items as proactively as this team has, it would be a lot easier to be a planning board member because you've taken care of all of those things. And I'm a proponent of solar if it's sited well. And I'm a proponent of this project because of that. If there was a lot of pushback from the other side of the table, it would be really hard to bite this bullet. But like Keith mentioned, I'm a grandmother to a little girl who's growing up, and I was part of the reason why she decided she was going to ground herself in animals and wildlife and everything that goes along with it. So I'm not going to break my trust with my granddaughter, but in this particular instance, I can defend my decision here. Thank you.
Very good, thank you. Anything else from planning board members? I just have a couple of thoughts to get out on the table, Sal Diorio. I was conflicted when this project first came before us. I was perhaps the only planning board member who was actually a part of this initial rezone application. I was more than a little disappointed when this project came before us. I really didn't feel that it belonged here. Didn't much care what the legal folks had to say. I was around and they weren't. So I felt that I knew best, and this wasn't a fit for me. However, I was then reminded that the horse had really left the barn on that particular topic. And I would recite, or I would direct your attention to items 4 and 5 in the decision, that solar applications and projects have been approved on this very parcel well before this applicant has arrived on our doorstep. And although I didn't participate in those proceedings, the time for the fight that has been raised by the opponents would have been much more appropriate when those applications were before the planning board, because then cogent arguments could have been made that this use does not belong on this property. However, that's a done deal, and that was one of the pivotal arguments that brought me on board with this project. So while it would not have been my preference, I think it's inappropriate to raise some of the arguments that I've heard at this late stage for this particular applicant, when other applications have been approved on the same site. So as a result, I'm a yes on this proposal.
Mr. Chairman, are we at the voting stage now?
We will be shortly. We're kind of at the stage where we're discussing the motion. So if there are revisions that you'd like to make to any of the items, if there's simply foundation that you'd like to lay for your eventual decision, I guess this would be the time.
Hey, thank you.
And then, Maggie, if I could impose on you, are there any housekeeping issues with the decision?
Well, there were some suggested changes to the verbiage, if you will, of the motion by Mr. Landry's office. I don't know how you want to handle that, whether you just want to deal with the motion as written or attend to incorporate changes. That's really how the chair wants to call it.
This is Carolyn. Can I make a comment? I want to speak to Mr. Gregory's concerns. While we were on our site walk, in attendance was Sergio, Jim Lamphere, and Ron Krelwitz and myself. A lot of attention was paid to the proximity of your property, your view to the site. And it was a much detailed discussion. A lot of attention was paid to protecting your position on your property and your rights. So the decision that we are reviewing tonight isn't slighting your needs. A lot of attention was paid to you as a resident. And I don't know if that gives you any comfort, but the planning board is doing its best to make sure that your concerns are addressed.
Okay,
and we don't perceive frivolous.
Carolyn, I'm terribly sorry to interrupt, but I've just gotten a text from Al that they're out again. So everybody stand by, please. And Talia is attempting to reconnect.
Yay.
That was quite positive.
Talia, we can see you. Can you see us? I mean, hear us. We cannot hear you.
Okay. Nope, now we're unmuted.
Okay, there we go. Thank you.
Yeah, it disconnected at about 8:42, and then it automatically tried to reconnect. And I guess when that happened, it made it so that it reset some of the settings. So I've now made it so that panelists can unmute themselves. I think that when it restarted again, it reset to the original setting, which is that panelists are muted on entry, but I've changed that. So now you can mute and unmute at will. So
Very good.
again,
Thank you, Talia.
we apologize for the delay.
Yep. So the last thing I heard was Carolyn was trying to interject with a comment.
Yes,
you
and
missed all the good stuff.
Okay. All right, well, we don't need to repeat it unless you need to, but someone would have
No,
to.
I can, the broad brush, Al, is that during the site visit that Ron and Jim and myself and Sergio were on, a lot of attention was paid to Mr. Gregory and the proximity of his home, his property, and his views. I just wanted to let him know that we weren't dismissing his concerns, that they were taken into consideration.
Very good, and we'll continue to be taken into consideration.
Correct.
Good.
And by the way, I am so excited about coming back to meet with you guys in person.
Well, we missed you too.
Oh.
Okay, so I was still grappling with the topic of whether there was housekeeping to attend to as a result of some of Mr. Landry's comments. Maggie, I have to defer to you here. If you suggested that we would entertain them, yeah, let's get them out in the open. Or if planning board members would prefer not to do that and are prepared to go with the decision as written, I'm okay with that too. Your preference entirely.
Right, Mr. Chairman, I'll review them briefly for you. There's really kind of wordsmithing, and I don't know that there aren't much substantive things here, but in item 6, that was reworded at the last sentence to say that delayed the closing on the property till after the town made such a confirmation, and he did not proceed with the development proposal until the town issued the zoning certificate described in paragraph 7. The next proposed change, give me a moment, I'm scrolling. Was in item 26. The last 3 words, "and battery storage," have been stricken, and it says, "or other storage permitted under the zoning ordinance." In item 20, paragraph 27, the word "battery" is stricken from storage building in 2 places. In item, paragraph 37, he corrected my spelling of Mr. Morano. I apologize, Mr. Morano. And also, the last sentence says, the proposal now includes just one 15,000 square foot building in addition to the solar array structures. Paragraph 48. After the words in the second line, recreational hiking, as a parentheses and pardon me, a comma, and says subject to agreements being finalized with the AMC. In conclusion of law number 7, on the bottom of page 9, the word multiple is included before structures. So it'll say, but rather included other commercial uses and multiple structures. The most substantive proposed change is in the order, paragraph number 1. And it says on the second line, for this stage of review only, and added comma, as a deferral as opposed to a permanent waiver. And then a few sentences added to the end of that paragraph, which state, it is noted that the need for a waiver is doubtful as to drainage, design, and calculations, as the information supplied is in line with what is expected at the conceptual master plan stage of review, comma, where precise design parameters are generally not available. To the extent that any deferral is deemed a waiver, comma, it is reasonable and within the general purpose and intent of the regulations and in the best interest of good planning practice, comma, particularly the staged approach required for a major land development project for a project consistent with a comprehensive community plan and zoning ordinance, period. And that is it. So, Mr. Chairman, if the board members who are inclined to approve this motion are comfortable with those proposed changes by Mr. Landry, the motion could be amended to incorporate those changes, and then you could proceed.
Thank you.
You're welcome.
Planning board members, how do you feel about these proposed revisions?
No objections from Carolyn.
Keith here, no objections, Ron.
I'm sorry, there was a little bit.
Yeah, it's Keith Lindelof, no problems with the. This is Ron. I have no objections.
So Carolyn, if you don't have any objections, it was your motion. Do you want to make a motion to amend your prior motion? And then Ron, perhaps you could second it, and then you're in position to vote on the entire amended motion.
Understood.
I would like to amend my motion to include the housekeeping matters that were requested by Attorney Landry and proposed by Maggie Hogan. I guess that would be it.
Yep, very good, thank you. Ron?
I'd like to second the proposal. Excuse me. I'd like to second the addition of the things presented by Attorney Landry.
Very good, thank you. So I have an amended motion. I'm going to have what I call an amended second. Is there any further discussion on the amendments or the final decision itself?
This is Carolyn. I have nothing else.
Okay, time to call for a vote on the motion.
Mr. Chairman, if you could do that by roll call, please, that would be good.
Yep, let's identify ourselves and indicate whether it's a yay or nay. So that would be Diorio, yes.
Perlowitz, yes.
Lindelof, no.
Light, yay.
Shamshinian, no.
So if my count is correct, I have 3 yeses, 2 nos.
Yes.
Yes, confirmed. So, motion passes.
Thank you. Have a good night.
Very good, thank you all.
Thank you. Good night.
Again, our apologies for the disruptions. Moving forward, on the next item on the agenda, I am going to recuse, as I have in the past. Again, my firm has performed surveying services for this applicant, although I am not involved with any aspect of this project. However, as a result, I'm recusing from the discussions. I'm handing a notice of recusal to Talia, and because of Ron's familiarity with this application, I would request that he take the reins on this one.
This is Talia. I'm accepting Al's recusal form.
Okay, it sounds like we are good to go. Good evening, everyone. This is on behalf of the applicant of Centrica Business Solutions. ESS Group has submitted a proposal for the construction of an approximately 3.46 megawatt DC ground-mounted photovoltaic solar energy system on approximately 7 acres of the 38.9 acre comprising condominium unit 2. Condominium unit number 2 is one of 3 condominium units condominium units located on an approximately 74-acre parcel. Now, if I could reach out to our town planner, Mr. Lampier, if he could bring us up to speed so everyone in the audience knows where we stand with this, and then we'll proceed.
Yes, Mr. Chairman, Jim Lampier, Town Planner. At the last meeting of the Planning Board, again, we attempted to divine the intent of the board, inclinations as to how they might want to vote on this application. We've heard the entire presentation from...
Hold on, everybody. I think we've lost them again.
We've heard public comment, yes. And so we have a motion, a proposed motion to approve that was prepared by our solicitor based upon the input that we received at the last meeting on July 7th. And I think that's, I would suggest we start there and do what we did on the last application, is solicit public input and exhaust that, and then go into the proposed motions.
And
Okay, thank you.
Mr. Chairman, it's Maggie
Yes.
Hogan. So before the board proceeds, you know that I have provided for you a draft motion as well as a draft memorandum that's presently internal only for the planning board members, simply because it's not finalized. But I'm prepared to finalize that and issue it within the next couple of days so that everyone knows what the advice has been. But I'd like to go over that because it speaks to the issue that you've heard raised again and again about the issue of vesting and the appropriate ordinance for review.
Okay, understood. Would you like
Okay.
to go ahead and do that now?
Yeah, I would like to. And I'd also like to note that when we get to the motion, please strike under the findings of fact, paragraph 2.
Okay, understood. Attorney Hogan, you have the floor.
One moment, please.
Certainly.
We have too many solar projects on the agenda in one evening. The memorandum that I want to speak to is on the next project, okay? So you can go ahead and go to the motion that I've prepared, but again, noting that paragraph 2 should be stricken because it does refer to a different project. I would also note that Attorney Rocha has sent in some proposed, again, minor revisions that we could handle in the same way we just handled the last one. I'm not entirely sure that the proposed revisions are consistent with my notes with the planner this evening on a couple of items as far as dates are concerned, but those are minor issues that we can get to. But you're in a position now to consider the drafted motion.
Okay, thank you.
You're welcome.
Board members. Board members. Do we have someone that would like to make the motion?
So if I can just be heard for a minute, I don't know if we're taking additional public comment like the last one. I was going to reserve, I just have a very brief summation to do, but I was going to save that in case you wanted to open it to public. It doesn't matter to me. This has been pending for some time. I thought about, since Carolyn did such a great job reading that very long decision, I thought about sending 6 more pages over, so we could take up a lot more time, but no, I will be very brief, but I'll do however you want to proceed.
Okay, who's speaking, please?
Joelle Rocha, sorry about that, attorney for the applicant.
Okay, thank you.
Mr. Chairman, Maggie Hogan again. hearing those comments, I have some recollection that we would be handling this matter the same way. And if the public has any additional commentary, it would be a good time to take it. I think you've heard them all, but you can give them the opportunity.
If you are a member of the public who would like to comment on this application, please press *9. And then when I read your name, you can press *6, or if you're on a computer, you can press a different button to unmute yourself. First member of the public, Eric, please state your name for the record.
Hi, it's Eric Bibler. I'd like to ask the planning solicitor to provide some clarification to the board. I'd like to ask through the chair if that's possible. I'd like to ask some questions that I'm unclear about. So first of all,
go ahead, ask.
Thank you. First of all, when the town council passes an ordinance, does the town council have to comply with it?
Mr. Chairman, that's not an appropriate question for me to be answering. He can ask the town solicitor that question.
Okay. Well, here's one that does pertain to this project. As you know, in section 6 of the zoning code lays out various dimensional regulation setbacks. They're called dimensional regulations, and they include things like setbacks from front, rear, side setbacks and coverage ratios and so forth. So it's my understanding that these regulations in section 6, which is a town ordinance passed by the town council, that all applications have to conform to these regulations, and that the town council is not able to issue a waiver for any of these dimensional regulations. A waiver for any of these aspects of this town ordinance and others like it need to be granted by the zoning board. Am I correct in the understanding that it requires a waiver from the zoning board in order to get relief from any of these conditions? So that wouldn't be the planning board is not able to grant those waivers, nor is the town council, is my understanding.
Mr. Bibler, I don't think I'm entirely following what your question is, but I would suggest to you that the town council enacted an ordinance in, I believe it was November of 2020 in regards to this application. And that particular ordinance has not been overturned by a superior court. And this body is now bound by the components of that particular legislative act.
Right, and I understand that.
I just wanted to add something, Mr. Chair. This project's not asking for any variances, so unless there's a specific question as the application, I'm not going to weigh in for the solicitor, but I would object to any hypothetical questions where this project isn't asking for zoning relief.
Right.
Okay,
so
understood.
What I'm trying to understand is that we had a existing master solar ordinance on the books. I think it's chapter 246, but it was enacted January 22nd, 2019. And I don't think there's been any controversy that that is the applicable, ordinance for review of this solar project. And in that solar ordinance, there's a limitation that's similar to these dimensional regulations that says that the maximum coverage ratio of the solar project is 3% or 3 acres. Now, I do understand that the town council voted an ordinance that says that they're okay with the idea in their zoning approval, their conditional zoning approval. They did say in their ordinance that they do not object to a project that's 9 acres, which is not in compliance with master solar ordinance. The same paragraph in the solar ordinance actually states that the town council may consider a more generous lot coverage ratio if the planning board recommends it. And when I asked this direct question during those hearings, Attorney Rocha admitted that the planning board never did recommend anything other than the 3% tolerance. And in fact, They didn't recommend approval. They actually did not refer any comp plan. They did not refer any recommendation whatsoever to the town council that any comp plan amendment be made. So I've asked this question before, and we always fall short of connecting the dots here. What I don't comprehend is if the town council writes an ordinance that says the maximum coverage ratio is 3% or 3 acres, and if the town council writes the same ordinance for itself that says that it may consider a different tolerance if the planning board recommends it, and if the planning board did not recommend it, how is it that the town council has the authority to ignore the ordinance and to just arbitrarily approve whatever acreage they like? And it seems to me that, you know, in other similar regulations, the zoning board has to grant a waiver. You know, the town council cannot simply ignore, you know, things like dimensional regulations or anything else. So I'm just trying to get some help and have the planning board understand how it is that we got from point A to point B, and why the planning board should make a positive finding. They need to make a positive finding that this complies with all the applicable ordinances. I can't see how this complies with chapter 246. Thank you.
Mr. Chairman, I'd like to address, first of all, the town council's zone change decision for this site is not, and I repeat, is not a conditional zone change. It was a zoning change. All of the elements of that zone change, to the extent that they conflict with any other prior ordinance, those prior ordinance provisions are superseded by the town council's action in the zone change in this matter. Whether we agree as a planning board or members of the community as to whether or not the town council followed the appropriate procedures in adopting that ordinance, that issue is not before you. You are not the Superior Court, and it is my understanding, we'll be discussing it the next application, that very issue was discussed and dismissed at the Superior Court just a few days ago. So what you have before you is a zoning amendment in November of 2020 by the town council. Those conditions are paramount. To the extent that there's an unanswered question by that, the underlying PSES ordinance in effect from 2019 will be the next document that you would review. And then of course, any underlying zoning issues not addressed by the two of those in the zoning ordinance as a whole.
Okay, thank you. That clears up quite a lot, actually. Talia, do we have anyone else with their hand up?
We do not, Ron.
Okay, thank you. Back to board members. What's your pleasure?
If I can just be heard briefly.
Certainly, go ahead.
Sure. So just to summarize, and I promise I will be brief. The project has been before you for several months, as you're well aware. You've seen the site. We revised the design at the council level after you had seen the project for the first time. We've provided you with the design. We revised the design based on feedback from your board during this process. And we've presented master plan level design, including stormwater and reports regarding the vegetation at the site and the vegetation to be removed. We've also had some significant conversations with the land trust, reaching a tentative agreement with conditions subject to the planning board approval of this project. I've gone into the issues on the record and in my correspondence raised by Mr. Bibler. We had a legal determination made, which was only further confirmed by Superior Court yesterday on the case that's before you next. which I'm sure, as you know, you'll hear about later this evening. We've talked about the comprehensive plan. Mr. Bibler has again noted that this board recommended denial of the zone change based on the comprehensive plan. As you're aware, that was a different analysis based on the use. I've heard comments earlier this evening about there should be no more solar on this project. What you haven't heard from is any abutters opposing this project. Unlike the previous application, this property is zoned solely for solar as a result of the zone change that was just discussed. It's a matter of working through with this board what the project at the site's going to look like. We certainly submit and will work with you hopefully going forward that this siting of this project presents the best design and location for the project possible and consistent with design standards in your comprehensive plan and zoning. The only remaining issue seems to be, at least in the proposed decision, the remediation at the site. And don't get mad at me until I finish, because it's good at the end. But we have talked a lot about some hypothetical conditions that may or may not exist at the property because of the previous use, and what might need to be done depending on the results of the testing and the findings before the project's constructed. There are a couple issues I do want to point out. The project before you is for solar at the site. The site's zone, commercial special, no longer residential. Many of the proposed conditions target the future use of the property by the land trust. It's certainly atypical and outside the scope of the project to have conditions or limitations targeted at a use not in front of the planning board. To the extent you relate the use to the findings that need to be made, that there is no significant environmental impacts from the proposed development as shown in the final plan. You've heard the emphasis in previous other projects that this is focused on the final plan. And that the reason for that being that there's a lot more due diligence done between now and the next stage, really. I want to be careful of considering issues and broad conditions at the master plan stage that involved any alleged environmental issues without allowing us and your peer reviewer to look at the details at the next stage in an effort to provide thoughtful solutions and ideas regarding potential remediation or lack thereof. We also want to remind the board that we've had numerous discussions with the land trust as the abutter and future steward of the property. We did so on a number of occasions. We came to a list of terms and conditions, one of which was an understanding that there may be pockets of this site that may not be able to be used for public use. The issue regarding the status of the property and condition of the property was contemplated in these discussions. That all being said, we've reviewed the decision and object to the conditions, but we do think some term clarification on the conditions as to one of the conditions, condition F, just to be more technical, it says the same thing for F, as well as some clarification of condition B. We're happy to discuss those things. We didn't tear it apart, so we're not talking about some significant changes. Some of the language is targeting clarification so the parties understand moving forward. But again, we're in this for the long haul if you let us be. So there's certainly going to be a lot more detail to talk about on this issue and all of these issues moving forward. So we are here for questions. If not, I would ask that you approve this at the master plan stage.
Okay, thank you. Something that's just going through my mind is we're being asked opinions and what we could possibly do, the way I understand it, from members of the community who have spoken tonight. The zone change, that's entirely in the hands of the town council. We have no control over what goes forward as far as their decisions. I mean, we have two attorneys on here. Please correct me if I'm wrong. At this point, the master plan is a conceptual idea of what you propose you're going to do. And from my understanding, as the planning board, we need to have input, or we have the potential opportunity to have input and to discuss this and to fine tune everything that goes from here forward. I mean, if I'm wrong, please let me know, but there's a lot of things that are being discussed that are really no concern of the planning board. We have no control over it. Whether we like it or not, it's not our position to change it or do anything about it, really. That's the rules. We have to follow the rules. Okay.
Mr. Chairman, Maggie Hogan, you're absolutely correct. So you've been handed a project that has a lot of conditions attached and parameters attached to it that you don't normally have that situation. A lot of those issues are things that you would normally handle from start to finish. The town council's zone change preempted your governing, if you will, in those areas. Yes, you can still discuss those areas, but you can't override something that the town council has said is appropriate for this site.
Okay, thank you.
You're welcome.
Board members, questions, comments? I hear none. Oh, go ahead, Carolyn.
Oh, there you go, stepping on me again. Ron, board, I just want everybody to keep in mind the unique characteristics associated with this project, in that the proposed solar project is scheduled to be constructed on a site that was formerly a junkyard. That was an interesting commercial application, and for 50 or 60 years, there wasn't any objection to it being a junkyard. Maybe the wildlife in the area had some objections, but nobody heard. So this project is taking into consideration the potential contamination issues that might exist, and they are unknown. And I'm a personal believer that there must be some pretty interesting conditions in the soils over there that potentially continue to affect the river. So while we walk through this opportunity, just like us to keep in mind that we have an opportunity to correct a wrong that was done previously, and again, allow a passive neighbor to coexist. And more so than any other project, I think that this is a win-win for our community and the habitat and the river and the land trust, etc. Thank you.
Okay, thank you. To touch on what Carolyn just said, I agree wholeheartedly. This remediation issue really cannot be addressed until after DEM gets in there and says, okay, here's what you've got. Here's what you're going to need to do. Then we can go there. There's something that's in the hands of the DEM. So until we know what's going on and all of that, we can't make any sort of a judgment or a suggestion to the applicant. I mean, we could have a really broad one that they're going to do everything that the DEM says, which actually they have to do, otherwise they don't get any building permit. So that being said, that's my 2 cents worth. Any other board members?
Yeah, I'll go. This is John. When we talk about the consistency with the comprehensive plan, I think part of that, and I'm going to agree with my colleagues Ron and Carolyn here, that the the potential for remediation and for righting a wrong is to me what speaks to the conservation goal. I don't think conservation is only paving part of the property. I think it's, you know, finding a way to make sure that it's ultimately in good shape for its ultimate use, because I think that ultimate use speaks to another issue with compatibility of the comprehensive plan, and that this become, you know, something for all of the townspeople. So in the interest of making sure that the town inherits something that is a wonderful natural resource, I think these issues are critical. And I think that they need to be addressed, not with, you know, we'll make a plan, but with, you know, definitive action.
Okay, thank you, John.
This is Emily. I'll just add a few things.
Sure,
First,
go ahead.
Thanks, Ron. Fully aware that my comments on the last application can kind of be used in the opposite fashion to support this one. You know, it is a small scale project. There's, you know, no abutters that have spoken out against this project publicly. And the environmental impact, as we've just been discussing, is, you know, not non-existent, but it's minimal considering, and it will improve the status of the subject property over the long term. I do want to talk a little bit about the recommended edits to this condition B about the remediation, just because, so what we, maybe it's more appropriate to talk about this after we make the motion, but just quickly, because I have a question about it. You know, we're sort of suggesting that remediation occur with an eye towards the eventual use, which is owned by the land trust, so that residents can use the land and not worry about whatever contamination might exist. And some of the edits that the applicant is proposing here is that in the initial phase of this project, they would remediate whatever is required for their proposed use, because that is customary. And they would essentially defer additional remediation until after the project is decommissioned. And if there's additional remediation needed at that time before the land trust takes over ownership, there'll be some sort of remedial action work plan to ensure that that remediation takes place. I'm okay with that. My question is, do we have any sense for when that will be? In one of our previous applications, we heard that the applicant had a contract with, I don't know what it was, an energy provider or the, you know, energy company or whatever, to sell energy to them for 25 years and the option to extend for 2 10-year periods. That sort of gives us a bound for like, how long are we talking about locking up this land use on this parcel for this use before it could ever be anything else ever again? I don't believe I could find mention of that level of detail from this applicant so far. I'm curious if there's any information they can share about that. And one of my suggested additions to the conditions, which may be appropriate at a later stage when we actually work on a decommissioning plan, is to be really clear about the date of decommissioning and state it, so that Hopkinton residents know when this, you know, return on their sort of investment in this project will bear fruit for them. So that's my question.
Okay, thank you. Was your intent to have Attorney Roca comment on that?
Sure.
Sure. So I hate that I sound like a broken record, but we're not at that level yet. I know these projects typically go 25. That's your typical setup. 10-year renewals aren't what I've seen, but 5 years are, like 2 5-year periods is typically what you see in these leases, 25 or 20, and then 2 5s. We haven't gotten there yet. We're working through those negotiations. That can certainly be a topic of discussion. We can definitely make a note should we get to preliminary plan and have that conversation. I think it's coupled with technology moving so quickly on this, but that can definitely be something to have a conversation about going forward and get you some information. Thanks.
Okay, thank you. Board members, anything else?
This is Carolyn. I want
Go
to
ahead.
echo Emily's concerns. Those were sticking points that stuck in my head when I read the agreement. Not the agreement. I have my eye on the grounds being remediated as they impact the wildlife and the plantings, understory, overstory, river. That's what I'm eyeing. I am not interested in hearing that this 50 square foot piece of property is subject to remediation and that's it. I'd like to know that the scope of this agreement and relationship is going to cover the overall concerns of the property in question that is going to be ultimately turned over to the land trust. And we're not going to be here 25, 30, 40, 50 years from now, but a good neighbor would take that into consideration, and I don't think it's a big stretch. There's opportunity for grant funding to support proper cleanup, and we'd like to know that all efforts have been made to address that. And I don't want the planning board to get boxed in somehow so that the bigger issue isn't addressed. And that's all I have to say on that. Thank you.
Okay, thank you, Carolyn. Along those lines, at the end of the project life, if there was something put in place, now this is a question I'm forming here for Attorney Hogan and Attorneys Roca. At the end of the project life, if there was something put in place that they have to certify through the DEM that has been remediated to the standards at that time, would that be an acceptable condition?
So that would be how it would work anyway. So once there is a triggering testing event, for lack of a better term, to DEM, it goes through this stepped process, which there's probably some table on the internet about it, where you submit a remedial action work plan, and then you basically get a certificate at the end of no further action, or like sort of like a closure, where that's certified at the end, meaning, you know, you're off the hook, you did what we asked you to do in the plan, and that's it. So that's how it works in theory. So once that remedial action work plan is done, it's not like, oh, you submit it and maybe you do it, maybe you don't. It's once that's triggered, the whole process has to be completed.
And this is Carolyn again. I do have some personal experience with remediation of some hazardous waste. And at the end of the day, I still possess the death certificate that I got from the company that removed the waste. And I was also told, don't ever lose it. So I personally know that it is a thorough process. I am just chiming in some extra thoughts on that. Thank you.
Okay, thank you, Carolyn. Anything else?
Sure, this is John again. So if entertaining this line of thought, how do we ensure that there is money to pay for a remediation effort as the site is decommissioned? We would need to understand the scope of the remediation work before putting anything into the ground. So is that what we're talking about? We're going to identify, there's going to be a test, and if there's a reportable concentration of any substance, that gets reported to DEM. DEM outlines what needs to be done, and at that point the applicant decides this is worth it or this is not worth it. Is that about right?
Well, it's my understanding that when DEM comes in and they do their testing now, they will have reports on file, and the applicant and or owner would keep those on file themselves. Whatever's in that ground, we'll know. When they pull up all of their posts and they decide that they're all done, they're going to move away, another DEM team comes in and says, you have additional things in there that you need to take care of. That would be the focal point.
So,
Does that, go ahead.
yeah, to add that, I think John's question is sort of, you know, who's holding the bag at the end of the day on this. That's something we've preliminarily talked about how to work this. We did come to the conclusion that it's so early that I think there's some mechanism that can be in place. We do feel like all the stakeholders, once we have more information at the next phase, including, you know, our team, the town's peer reviewer, and the land trust, can probably work towards that, addressing that issue. It's hard now to have, we've got these hypothetical, you know, concerns, which may be concerns, we don't know to what level, but I think that's certainly a conversation, because it goes hand in hand to the stuff you have to review at preliminary plan anyway. That it is, trust me, it's starred in the notes of things we need to do and talk about at the next phase.
Okay, thank you.
Mr. Chairman, this is Jim Lampier, Town Planner. Can I interject a little bit here on this?
Absolutely. You're more than welcome.
I've seen literature on this case where the Hopkinton Land Trust was going to get access to this property at some point by easement. By easement, I wouldn't have any objection to, but when it comes to any agency of the town of Hopkinton actually taking ownership of any of this property, I don't think I would agree with that. I don't see where there's anything to gain from the town of Hopkinton from owning this. Currently, the town does not own it. It is owned by a private party who is responsible for whatever may be in that ground, who is responsible to remediate things should DEM say it needs remediating, and who would be responsible going into the future for monitoring, possible groundwater monitoring, gas monitoring. I would not have the town of Hopkinton take ownership of any of this property. Right now, they own it, and they're going to be responsible going into the future for it. That would be my advice based upon what I've encountered on the Stubbtown landfill that the town already owns, and the responsibilities that the town already has, expenses that we have to make, not only close these things out, but to monitor them on an ongoing basis. There is nothing at all in it for the town of Hopkinton to take ownership of any of this property. That's my opinion.
Okay, thank you, Mr. Lampier. That's a very good point. Board members, what's your pleasure?
And just to be
I
clear
think at
on,
this point-
just to
Go
clarify
ahead.
one thing, to be clear on that, the council zone change conditioned an easement. In our conversations with the land trust, they preferred ownership, but that's not, you know, there's no signed agreement. We do have terms, but that's can be an open conversation going forward as well, in conjunction with this whole other issue. So, but I hear Jim's point.
I wouldn't take
Okay,
ownership
very
of that property unless our town solicitor approved it. That would have to get legal review from my standpoint.
Okay, there again, to sound pig-headed, I guess you'd say I'm pig-headed. We're in the conceptual stage now. All this ownership and all that other stuff can be ironed out later. You know, before the final go ahead or don't go ahead. So to keep beleaguer and the fact that, well, we don't want to own it, we do want to own it, I think that's something that's going to happen in the future and the very near future. next few
Yeah,
months.
Mr. Chairman, Jim Lanfear, Town Planner. The only reason why I bring it up is because it's in the proposed motion that's going to be on the floor for discussion, so it says ownership right there, so.
Oh, okay, I'm sorry, I skipped over that part, I guess. I apologize.
Yeah, I didn't read that as like it has to be, the town has to own it. So, you know, you guys can amend that if you need to, but that's not our reading of it.
I would avoid it, abundance of caution.
Okay, thank you, Mr. Lanfear. Board members, would somebody like to make a motion?
Yeah, Keith here. I'll go.
This is Talia, quick interjection. Wait, hold on. So this is Talia. There is still another member of the public, and as you did for the previous application, you probably will want to have a motion to close the public informational meeting before you make a motion on the motion. So would
Okay,
you like to hear
understood.
from the member of the public and then make that motion? Okay.
Sure. Yeah, absolutely. Go ahead.
All right, so I'm going to read off the last four digits. The phone number, 8222. Please state your name for the record. After pressing *6.
Hi, this is Joe Moreau. I'm sorry. I don't know if it was a technical issue with the thunderstorm, but I tried getting in during the public comment period. But I'll make this real quick. I just wanted to thank Attorney Hogan, Rocha, and the chair tonight for setting the record straight and pointing out the inappropriate question by the first speaker. Scott Billhurst continues to receive criticism for his approval of this project. He voted yes mainly to clean up the problems, especially with the junkyard. And I'm glad to hear that that issue will be taken care of. And I agree with what the planning board members said, that the DEM will be involved and we can rest assured that that project will be cleaned up. Again, thank you for your time. I appreciate it.
Thank you, Joe.
You're welcome.
Okay, we're back to the motion state. I think, if I understood it correctly, we should now seek a motion to close the hearing. Or informational
Close
meeting.
the public informational meeting. Yes.
I move to close the public informational meeting.
We have a motion. Do we have a second?
Carolyn, yes. Second.
Okay, we have a motion and a second. We'll vote by roll. Hurlwitz, yes.
Bindalow, yes.
Light, yes.
Jumshia, yes.
Penny Packer, yes.
And it's unanimous. Okay, thank you. Now, if I'm understanding things correctly, we can move on to the motion that was proposed before.
I started, I guess I'll continue. So Keith Lindelof here again. I move to approve Centrica Business Solutions application for master plan for a photovoltaic solar energy system located at 136 Chasestone Road, AT2, Lot 73, Unit 2, based on the following findings of facts and conclusions of law. Findings of fact. Number one, the subject property located off Chase Hill Road, consisting of 38.8 acres, is zoned commercial special by virtue of a zoning amendment with development conditions dated November 2nd, 2020, a copy of which is attached as Exhibit A. The Planning Board had previously recommended denial of the zoning amendment. Two, the zoning amendment was challenged in the Rhode Island Superior Court by Eric Bibler, Colleen Steffen, Jane Rathburn, Janice Tapley, and Richard Noel.
Wait, hold on, Keith. I believe that you are reading the motion for Skunk Hill and not the motion for Camoli.
No, that's
Oh, number 2 is stricken.
stricken, exactly. It was placed in the wrong, I was making too many motions at one time. My apologies,
Very good.
Keith, I should have reminded you.
Yeah, thank you.
Sorry for that interjection.
No worries.
I was about to.
Number 3, number 2 actually, right? The master plan application was filed on December 18th, 2020, and the pre-application meeting was conducted on January 6th, 2021. Number 3, on April 19th, 2021, prior to the town of Hopkinton's adoption of Chapter 279 of the zoning ordinance, the applicant submitted the last document required for master plan review checklist. 4, subject to the applicant's supplemental submission to the town's planning department on April 19th, 2021, the Hopkinton Town Council repealed the town's photovoltaic solar energy system ordinance dated January 2019 and enacted Chapter 279. 5, the planner issued an administrative certificate of completeness on April 29, 2021. 6, the proposed site is 38-acre lot land condominium unit, Unit 2 of 3, accessed by an existing gravel road that passes through Unit 1. The site was historically used as an automobile junkyard for approximately 50 years and for quarrying. Number 7, the subject property has numerous areas of jurisdictional freshwater wetlands and is located in a Hopkinton primary protection zone for groundwater protection. 8, the proposal is to construct a 3.46 MW direct current DC ground-mounted photovoltaic solar energy system, PSES, occupying 8.1 acres, associated electrical equipment, and install approximately 9 new utility poles, all surrounded by chain link fence. The proposed array will be located at 989 feet. It will be located 998 feet south of Chase Hill Road. Number 9, the proposed solar array will not be visible from any passersby on Chase Hill Road, nor from the Polly Coon Bridge or any adjacent residential dwelling. Number 10, the proposed solar array will be constructed on a site that has been substantially disturbed due to long-time use as an automobile junkyard. 11, on January 21, 2021, ESS Group submitted an analysis of the feasibility of development on an abutting property in the vicinity of solar array, concluding that development was not likely to be permitted by RIDEM's freshwater wetland section. Number 12, the Hopkinton Conservation Commission submitted notes from a site visit conducted on March 29, 2021. 13, on December 31, 2020, and February 8, 2021, the Hopkinton Land Trust submitted correspondence. 14, on April 22, 2021, the applicant submitted revised plans showing the solar array is being set back 100 feet from the property line. Correspondence with the submission stated that this setback was not conceded as a requirement, but was being set forth as an illustration. Correspondence also indicated that if the solar array was set back 100 feet from the property line, the applicant would be seeking to clear some portions of the 100-foot setback. 15, on May 19, 2021, the applicant presented testimony from Jason Gold, engineer, Edward Pimentel, land use planner, consultant, and Kelly Connolly, landscape architect. 16, Mr. Gold testified that as a result of the pre-application meeting, the applicant had made changes to the driveway design, the stormwater design, and grading. Additionally, the size of the fenced area also decreased from 9.07 acres to 8.1 acres. The number of panels decreased by a little more than 1,000 panels, from 8,764 to 7,758. 17, Mr. Pimentel testified that the development of this site for a solar array was consistent with state efforts to encourage the pursuit of solar in areas that have been zoned commercial or industrial, or on sites that have been previously disturbed, such as brownfields, quarry sires, sand pits, and contaminated sites. He further averred that the eventual transfer of the property to the land trust was unique and was a worthy goal. 18, Ms. Kelly testified as to the existing vegetation and site topography and the proposed landscape condition. 19, on June 3rd, 2021, 2 planning board members visited the site with a representative of the applicant's engineering firm. Other members of the planning board had previously visited the site with the Hopkinton Conservation Commission. 3 members described these visits as illuminating and confirmed in their minds that the solar array will not be visible from off-site. Number 20, the board accepted oral and written comments from members of the public during the course of the proceedings. Conclusions of law. 1. The application for master plan was substantially complete for the purposes of Article 12 of the Hopkinton zoning ordinance on April 19, 2020, prior to the enactment of Chapter 279. The application's review is vested to proceed under the terms of Chapter 246, as well as with the terms and conditions of the November 2020 zoning amendment. 2, the proposed development is consistent with the comprehensive community plan and/or has satisfactorily addressed the issues where there may be inconsistencies. Specifically, the project is consistent with A, conservation goal number 1, to promote conservation of natural resources by limiting the development to 11.5 acres of a total of 38.8. B, natural resources goal number 1, to preserve, conserve, and protect natural resources as an endowment to the town by donating the ownership of the property to the Hopkinton Land Trust after decommissioning. 3, with the 100-foot setback amendment to the 100-foot setback amendment to the plan, the proposed development is consistent with the Hopkinton zoning ordinance as further amended on November 20, 2020. 4, at present, there appears to be sufficient assurances that there will be no significant negative. Let's read that one again. Sorry, everybody. At present, there appears to be sufficient assurances that there will be no significant negative environmental impacts from the proposed development. However, this is one issue that will be addressed in detail at the preliminary plan stage review, and the board reserves all right to make final determination on an issue and to impose additional conditions, all at the preliminary plan stage of review. 5, the proposed land developments will have adequate and permanent physical address to a public street, Chase Hill Road. 6, the proposed development provides for safe circulation of pedestrian and vehicular traffic, for surface water runoff control, for suitable building sites, and for preservation of natural, historical, and cultural features that contributes to the attractiveness of the community with the required conditions of approval. Specifically, the development was reduced in scope to prohibit any view of the solar array from the Polly Coon Bridge or the adjacent land trust property. Upon decommissioning of the solar array, the ownership of the property will be conveyed to the Hopkinton Land Trust for the benefit of Hopkinton residents. 7, the design and location of the improvements in the proposed development minimizes flooding and soil erosion with required conditions of approval. This issue is one that will be addressed in further detail at the preliminary plan stage review, and the board reserves all rights to make final determination on an issue and to impose additional conditions, all at the preliminary plan stage of review. Order. Number 1, Centrica Business Solutions application for master plan is hereby approved with the following conditions of approval to be developed at the preliminary plan stage of review. A, all conditions of the zone change approval dated November 2nd, 2020 are specifically incorporated herein and made a part hereof. See Exhibit A. B, the applicant shall be required to conduct all remediation deemed necessary by Rhode Island DEM for the eventual use of the property as land trust property to be owned by Hopkinton Land Trust for the benefit of Hopkinton residents. C, upon approval of the master plan, the applicant shall verify in writing to the town that it has ceased commercial coring operations on the property. Non-commercial coring hereafter shall solely be limited to site preparation for the installation of the solar array and shall thereafter permanently cease. D, the applicant shall be required to move all obvious junk and surface debris on the site that is not apparent that the site was once a junkyard. This requirement shall not be construed as to require fine-tooth combing of the property. E, the applicant shall correct a notation on the sheet R1 plan as to the appropriate zoning for the subject parcel. F, the applicant shall undertake a Phase 2 environmental study and submit the result of that analysis to the town prior to or at submission of the preliminary plan application. In addition, the applicant shall copy the town planning department on all correspondence to and from RIDEM or any other governmental agency in regards to environmental issues on site. G, the applicant is directed to consult with and work with the Hopkinton Land Trust on the required decommissioning plan and reforestation plan. H, the applicant is directed to prepare a plan for the preliminary stage of review to provide third-party supervisory personnel at the applicant's expense to observe and oversee compliance and ensure compliance with the proposed construction. I, the applicant shall anticipate and expect that the planning board will, at the preliminary stage of review, consider the imposition of a performance bond to ensure strict compliance with the terms of any approval, especially in regards to the amount and location of tree cutting and on-site topsoil preservation. J, the applicant shall submit a decommissioning plan at the preliminary stage of review. K, the applicant shall include pollinator habitat and wildflowers in the landscaping plan at the preliminary stage of review and shall develop a plan that requires minimal amount of fertilization or other chemical maintenance. Lastly, L, at the preliminary stage of review, the applicant shall address all items set forth in letters from the Hopkinton Land Trust dated December 31, 2020.
Okay, thank you, Keith. We have a motion. Do we have a second?
This is Carolyn. Based on previous discussion, I think we might want to consider amending some of this. And I would point to the conclusions of law, paragraph 6. We don't have line numbers here, but let's go to the third line to the bottom. Upon decommissioning of the solar array, the potential ownership of the property may be conveyed to the Hopkinton Land Trust for the benefit of Hopkinton residents.
So, Carolyn, excuse me for just a moment. So, technically, you can't amend the motion until it's been seconded. So we got to have a second first, and then you can have your discussion, and then you can make the amendments all at one time. How's that?
Maggie, this is Talia. Carolyn did second the motion.
I didn't hear that. I apologize. I didn't hear the second.
Neither did I, Maggie.
I thought that you had seconded it, Carolyn. I'm sorry.
I'll second the motion. I did, but I'm doing it again. Are we good?
Yeah.
So we need to take a vote. And was seconded.
You're not going to vote on the motion yet. Now you're open for discussion. Go ahead.
Open for discussion. Okay.
Yep.
Let's go back to what I just said. Number 6.
Yep.
The third line from the bottom, upon decommissioning of the solar array, the potential ownership of the property may be conveyed to the Hopkinton Land Trust for the benefit of the Hopkinton residents. And my second comment on that, these are in conjunction, is to the order, number 1. B, the applicant shall be required to conduct all remediation deemed necessary by the Rhode Island DEM for the eventual, this should be changed to potential use of the property as land trust easement by the Hopkinton Land Trust for the benefit of Hopkinton residents. Those are based on Jim's comments, and I guess the planning board needs to have some chatter on that. Thank you.
Hi, this is John.
Okay,
I'll go first.
thank you, Carolyn.
Oh.
Go ahead, Keith.
Oh, it was John. Sorry. Yeah,
I'm sorry.
I'm with Carolyn in what she's saying, but I kind of want to wordsmith this a little bit. Can we use, for example, ownership or stewardship? That way we're not talking about potential ownership. We're talking that it's basically saying that the land trust is going to have authority over the land, whether it's via easement through stewardship or whether it's via, some ownership plan. that strengthens that doesn't weaken the land trust position, at least from my perspective. And I think we could, do ownership / stewardship in both examples. Thoughts?
That's why you get paid the big bucks, John.
Okay, thank you.
Mr. Chairman, I have a series of minor amendments as well that came in from Attorney Rocha, and they're basically errors that need to be corrected. And in paragraphs 4, 5, and 6, the dates are all March 18. Okay.
Okay.
And in paragraphs 1 and 7, the size of the property is 38.9 plus or minus, not 38.8. And in paragraph 17, she proposes the plus or minus as to all those acreage, that's fine. And on paragraph 20, and I think this is accurate as well, there was one planning board member, I believe that was Emily, visited the site. I kept thinking that John was with us, but that was the other site. Also in conclusions of law, the date changed from April 19 to March 18. And then in the ordering paragraph, the one that you folks are speaking with, there are some proposed kind of some substantial changes there. So I'll read that paragraph in just a moment and see if you like it with your changes. And then there's a proposed change in paragraph F of the order corresponding to B. So that's it for the technical elements.
And this is John. Yeah, if I can weigh in again, I think that there are the technical ones that I think are no-brainers. I got a couple of doozies as well, so I'm wondering if we should approve these amendments in batches.
Sure.
Go ahead, John.
That would be me again, right? I move to approve the proposed amendment changes as read by Attorney Hogan. Is that correct?
Well, we have a motion. Do we have a second?
Sure, this is John. I'll second the technical changes.
Okay, thank you. We have a motion and a second. Planning board members, we'll go by roll. Krulwich, yes.
Lindelof, yes.
Light, yes.
I just want to be clear what we're voting on. Should we
you're amending the draft motion, and you're not voting on the motion it's as amended. You're just voting to amend the motion for draft purposes. And then I believe there's additional amendments coming from John. That's what I understand.
Okay. I just wanted to be super clear.
So this is a technical amendment to the motion. You're not voting on the amended motion.
Got it. Shamshinia, yes.
Pennypacker, yes. And with that comes a question. Keith's identified those as Attorney Hogan's technical amendments. Does that include the ownership / stewardship amendment?
I believe they would, yes. That Ms. Light had recommended. Yes.
Yeah. Okay, thank you.
Yeah. The ones to date. So you still need to finish voting on that, I believe.
Okay, it sounds like we have a unanimous vote for the amendments. And I'll address this to Attorney Hogan. Are we good to go ahead and vote on
no,
the whole?
You're not voting on because it's not fully amended yet, as I understand it. Those were technical. Now, I believe John Pennypacker has some substantive amendments that he would like to make. Is that correct?
That is correct.
Okay.
Certainly. Sorry, John. I overstepped that a little bit. Go ahead, John.
No problem. Thank you. This is John. So as it is stated currently, I'm under conclusions of law 2A. I can't agree, or I cannot vote for this motion the way it's worded currently. I don't believe that limiting development meets a conservation goal. However, I do agree that addressing remediation issues and concerns, or potential remediation issues and concerns, does agree with the comprehensive plan. So I propose that 2A read conservation goal number 1, to promote conservation of natural resources by addressing potential remediation issues and concerns. And if that needs to be worded more clearly, I would defer to the solicitor. Second, we covered that one. Second is, again, under conclusions of law, item 2C. Sorry, I'm cross-referencing 2 documents here. Oh no, there's no C. I would propose that we add a 3rd item. It offers a little bit of consistency with the previous decision, and that would be C, economic development goal number 1, to provide for the expansion of the town's tax base by encouraging development of new and existing light industrial and office and commercial business. And the reason I propose that 3rd one, I think it more closely aligns with the intention that the town council created when it changed the zoning of this property. And I think it's in line with the previous decision. So those are my 2 suggestions.
Okay, thank you, John. So, Attorney Hogan, do we need another motion to accept or approve John's amendments as well?
So right now he's got a substantive change, and we can come back to it, and because I think there's probably another substantive change that could be coming. Well, could be. I'm going to propose to you the substantive change that Ms. Rocha has sent to us, and that's in the order, paragraph 1B. And I have forwarded this to everybody by email, prior to the meeting late in the day today. But this is how it reads, as amended by Ms. Light and now as proposed. If reportable concentrations of hazardous substances are detected, the applicant shall be required to conduct all remediation deemed necessary by the RIDEM's Office of Land Revitalization and Sustainable Materials Management Site Remediation Program, parentheses, OLRSMMSRP, for the proposed use of the property. Additional remediation to the extent it is required by RIDEM OLRSMMSRP shall accommodate the potential use of the property as land trust easement to be held by the Hopkinton Land Trust for the stewardship benefit of Hopkinton residents, shall be addressed in a remedial action work plan at decommissioning prior to the transfer of property, prior to the creation of any easement in the property to the Hopkinton Land Trust. Is that what you anticipate, Joelle? Did I get that correct?
So I think it can, just my opinion, I think it can still say transfer, because whether it's an easement or it's
True.
at the end of the decommissioning, I don't know that it matters, just to
That's
not muddy
fine.
it up more.
Yep, that's fine. Are people comfortable with that proposed language? I see some shaking heads.
Yep.
Possibly.
This
This is Ron, yes, I'm comfortable with it.
Well, this is John, I'll provide the opposite. I don't see how that strengthens the town's position in any way. So convince me that it makes the town convince me that it's better for Hopkinton and I'll get on board.
So, as I understand the changes here, basically it identified the specific office and then added additional remediation. So what was your concern, John? I'm not.
So, all right, so it starts off with a conditional, if reportable concentrations are detected.
Yep.
I think that's standard operating procedure for that process anyway, so I don't know why it needs to be duplicated. And then we get into the specific office within DEM. That office is 2 years old. Is it going to change? What if another office within DEM has authority over this? I don't know that naming the specific office within the division offers us anything other than it just limits our ability to act in the future if a different office within DEM says, oh, wait, you have an issue.
Well, of course, you could put or any successor, but again, it's more language. If your position is, look, let's just go with the language as originally proposed, you know, you could certainly make that suggestion.
If you, just a suggestion, you could just say that RIDEM office with jurisdiction. That gets a lot of language out. A lot of words out.
A lot of letters.
Okay, so where do we stand? John, are you happy with that?
This is John. Yes, I'm happy with office with jurisdiction within DEM or however that's phrased.
Okay, thank you. Any other comments or concerns from the board?
So you'd need a motion now to add the substantive amendments to the main motion and vote on that, and then you're ready to vote on the entire motion.
This is John. Can I just
move.
Okay, thank you.
This is John.
Yeah, go ahead, John.
Just one last question before moving forward on this. This sets it, basically, this writes it down that any remedial action that's going to be taken before transfer will happen at the end of the project. Does that need to be decided here?
It doesn't. You can decide that at the preliminary stage.
Even if we pass this motion with this potential amendment? Or we would have to...
If this is the master stage of approval, so if you're gonna create that condition now, and they're gonna rely on it, you don't wanna go back on it. So if you're not ready to commit to when these things should be done, you could simply say that the applicant is going to need to conduct remediation, and this is going to be determined at the preliminary plan stage of review. That's the scope of it.
That makes me happier in that the town has more options. As I think we're all aware, there are a lot of unknowns, and I'm reluctant to commit to a particular plan of action at this phase, given the uncertainties.
So I interpret that, John, to mean a motion to strike paragraph B as written, and that you would support something along the lines of the applicant shall submit a remediation report and plan at the preliminary stage of review for the board's action. That sound about right?
This is John, yes.
Okay, we're making progress. Do we have a motion to approve the amendments that John proposed?
Yeah, I move to approve the substantive amendment changes as proposed by John Pennypacker and suggested by Attorney Hogan.
Okay, thank you. We have a motion. Do we have a second?
This is Carolyn, second.
We have a motion and a second. We can vote by roll. Prelowitz, yes.
Lindelo, yes.
Light, yes.
Shamshinia, yes.
Penny Packard, yes.
Okay, the
And
ayes
now-
have it. Yes.
And now, Ron, you'll take a motion on the order, the decision as amended twice this evening.
Okay. We heard it, folks. Do we have a motion?
Oh, I'm sorry, I missed that. What's the new motion? I'm sorry.
The motion now would be to approve the entire document that has been amended twice this evening.
Right. I'm sorry. I move to approve the motion as twice amended.
Okay, thank you. Do we have a motion? Do we have a second?
Light, second.
We have a motion and a second. We'll vote by roll. Prelowitz, yes.
Lindelo, yes.
Light, yes.
Genia, yes.
Penny Packard, yes.
And the motion passes.
Thank you all
And I
very
will
much.
defer. You're welcome. Thank you for your participation.
Good luck.
Attorney Hogan, are we clear to move the meeting back over to the chairman?
Yes, we are, Mr. Prowitz.
Okay, at this time, I'd like to return the chair to Al Diorio. Thank you, Al.
Thank you, Ron. I appreciate it.
You're welcome.
So I would direct everyone's attention to the clock. I showed 10:10. So the third item on our agenda this evening, in all likelihood, let's see, we have some instructions here. We're close enough to the 10:15 mark so that from a practical perspective, this application is not going to be heard this evening. So we're going to need a motion to continue. However, before we get there, since the motion would need to contain a date and time certain, I would just ask Jim Lamphere to suggest to us where we need to continue this to. And then I'm going to ask the applicant's counsel to, or maybe Jim can handle this, but in concert with the applicant's counsel, to ensure that we have an appropriate extension in place to cover us to that date certain. So Jim, if you would.
Well, Jim Lamphere, Town Planner. I can tell you that I probably have 5 items on the agenda for August the 4th. One of them is going to take quite a bit of time to go through. I don't know how much we could get done with Skunk Hill if we continued it to August the 4th. We're not going to have a second meeting in the month of August. So our next meeting in September, I think, is what, September 1st, is it?
It looks like September 1st, that would be correct. So is it your recommendation that we strike toward September 1st?
I think, I'd like to hear from the applicant's attorney to see how they feel about this whole case moving forward, and if they're fine with that.
Well, we can certainly do that, but, come on, let's be realistic. If August is not going to work because we have previously scheduled commitments, then I don't want to be holding out August as an option. I realize that tonight kind of went sideways on us, but, okay, we can't control everything.
I would say August 4th is not available.
Okay, it's as simple as that. So that said, I presume the applicant and/or their representative is still out there this evening. So the only remaining business item is to ensure that we have an extension on the record to get us to at least September 1st. So if the applicant and/or their representative is out there, this would be your opportunity.
Can you hear me, Mr. Chairman?
Yes, I can. Thank you.
It's Attorney Bob Craven. I represent Skunk Hill. In light of what Jim Lanfear has told you as to the availability of time on August 4th, it seems like it wouldn't be any better, maybe worse than tonight was in reference to reaching the substance of the remainder of this project. So I'll be okay with September 1st as the next available date.
Very good, thank you. And so just for the record, can we get your concurrence that in fact we have an extension? And if we could just kick it to, a week beyond September 1st, just in the likelihood that, things go sideways on us. Would that be acceptable to you?
It is.
So just for the record, could we have it the date of, say, September 8th? Would that be acceptable?
I concur, Mr. Chairman, and I'll say it in full sentence. I agree that the matter, as far as the time frame is concerned, under the statute, can be continued to September 8th.
Very good. Thank you so much. So then, all that said, planning board members, could I have a motion to continue this application forward to our next, not the next, but a regular meeting on September 1st? And just Jim, clarify, are we still going to continue at 6 o'clock?
I would suggest that, yes.
Okay, so September 1st at 6 o'clock, if I could have a motion to that effect, please.
This is Ron. I'd like to make a motion that we continue this until September 1st at 6 o'clock, or the September 1st at 6 o'clock meeting, I should say.
Very good. I have a motion.
This is Carolyn. I've been seconding things all night, so I'm going to second this one too.
Very good. Thank you so much. I have a motion. I have a second. Any further discussion on this motion? Hearing none. All in favor? Diorio, yes.
Relowitz, yes.
Lindelof, yes.
Knight, yes.
Comchinia, yes.
Very good. Thank you. And again, I want to thank the applicant for being so amenable to our schedule. Thank you.
Thank you.
Okay, we have a few more administrative tasks to contend with before we conclude this evening. Under new business, I have none. Under solicitor's report, I have none. Under planner's report, I have none. Anything to add?
I'd just like to add that this afternoon, Talia and I had lunch with former senior planning clerk Sean Henry, and we learned a lot as to what they're doing in North Kingstown these days. So it was a working lunch, and Sean said to make sure that I say hi to all the board members tonight.
That is very nice. Thank you. Do you see Sean with regularity?
Not with regularity, no.
Next time you see him, you'll reciprocate and give him our best.
Will do.
Okay, very good. Thank you for mentioning that. Under correspondence and updates, I have none. Next item on the agenda is public forum. Is there anyone still out there?
There is. Eric, please state your name for the record.
That was a mistake. I'm sorry.
Okay, don't worry about it.
Anyone else out there?
If there are any other members of the public who would like to speak during public forum, please press *9. Nope.
No hands. Okay, very good. Next item on the agenda is the date of our next regular meeting. That would be August 4th. And if there is nothing that can legitimately come before us, I would entertain a motion to adjourn.
I'd like to make a motion, we adjourn the meeting.
I have a motion.
Ron, don't be so fast. This is Carolyn. I'll second it.
Of course. Carolyn seconds. We have a motion, we have a second. Any further discussion on the motion? Otherwise, all in favor? Yorio, yes.
Hurlwitz, yes.
Lindelof, yes.
Light, yes.
Tomshinia, yes.
Okay, very good. I thank you all very much. Everybody have a good evening.
Thank you. You too.